Well, good morning. Welcome to day 48 of our coverage of the Aurora movie theater shooting trial. This morning we are going to go into court without a jury. This is not a day for the trial itself. This is actually a day for a hearing that is to finalize the jury's instructions and jury forms that they'll be filling out as they deliberate starting as early as tomorrow afternoon and certainly carrying us through the rest of this week. Tomorrow morning at this time we will be talking about closing arguments, but today we're going to get those jury instructions and forms finalized and out of the way so that both sides can present their 2 hours of closing arguments tomorrow. This is the 48th day. Tomorrow will be the 49th day of this trial. 3 of those days have included openings, another hearing, and now this today. At this point, we have been through many, many weeks of testimony through 4 different expert doctors, through 2 different assertions and theories of how mental illness played a role in this crime, and that's certainly going to be a key decision-making factor for this jury, and it's something that both sides are very careful about in the wording that they try to propose for these instructions and forms, as we've heard starting Friday afternoon, So what we'd like to do for you this morning is to resume with a little bit of that, the debate over these jury forms, the wording on them, since it is so important that they are having now a second day of debate over this. And so Andrew and I want to play that video for you now. Once court does pick up for this morning, it's supposed to happen around 9 a.m., which is 8.5 minutes from now. At that point, we'll resume and take the court live.
Given the issues in this case, and given that this is a capital case in which a plea of not guilty by reason of insanity has been entered, my first concern, I have a couple of different concerns, 2 main concerns with the verdict forms. The first is the separation into Part A and Part B, and the special interrogatory inquiring about the not guilty finding being based solely on the a finding of the not guilty by reason of insanity. Our proposed verdict form, as I'm sure the court saw, breaks it down very simply. It gives the jury 3 choices: not guilty by reason of insanity, or guilty of either the charged offense or one of the lesser included offenses. I think that's totally compliant with the law, with the Constitution, and it clearly lays out for the jury that they essentially have 3 different options in terms of their verdict for each count. The way that the verdict form is currently structured, it doesn't make that clear to the jurors. The jurors know, obviously, that we've entered a plea of not guilty by reason of insanity in this case. I understand that. I also understand that they've been instructed on the affirmative defense of insanity within the court's instructions. But when they get to the verdict form, the first page of the verdict form just simply asks them for a verdict of not guilty or guilty. And it doesn't mention anything about insanity at all. And furthermore, the instructions and the instruction that tries to explain how to fill out this form also doesn't make any mention of, in filling out Part A, you should mark the form, check the box, not guilty, if you find the defendant not guilty for any reason, including that the prosecution hasn't established the element of insanity beyond a reasonable doubt. So I have a lot of concern about the way that the form is structured and the fact that it's a problem. I think in some respects it's analogous to the issue in Beck versus Alabama. It's not made clear to the jury that they have this third option of not guilty by reason of insanity. I don't see any reason why we shouldn't make it abundantly clear to the jury that really a finding of not guilty and not guilty by reason of insanity just be separated out to make that very clear. And so we object to the way that the court has structured the verdict forms, as well as to the special interrogatory, as well as to the instructions on how to fill out the verdict forms. Our first proposal, that's the first argument. And I should note that in another high-profile insanity case that happened a couple of years ago that Ms. Spengler was involved in the Bruco-Eastwood case, the court did the verdict forms the way that we proposed, laying them out separately, the not guilty option, not guilty by reason of insanity, and then the guilty. And I have copies of those verdict forms if the court would like to see them at any point. Second concern I have is with the interrogatory that states that the jury should only fill out this Part B, this interrogatory, if they have concluded, if they have found the defendant not guilty by reason of insanity on all, or not guilty on all counts, excuse me. This, and again, I understand the case law, but to me this is a directed verdict, and it would violate Mr. Holmes's right to due process, and as well as the heightened reliability required by the 8th Amendment and Article 2, Section 20 of the Colorado Constitution. I'm not convinced that this is a correct statement of the law, because I think, at least conceivably, it's possible that the jury could find him guilty of the explosives count, not guilty of by reason of insanity on the murder and attempted murder counts, and he could be sent to the Department of Corrections to serve a sentence for the explosives count, and then later committed on the NGRI counts. So to the extent that the rationale in Bilecki and the statute is that it's the only purpose for the special interrogatory is for the court to determine whether the defendant should be sent to the Department of Corrections or to the state hospital, I'm not concerned at all about this court's ability to determine where the defendant should be placed, certainly. But what I am concerned about is totally confusing the jury. It's not necessary at all, and it's more than not necessary. It's a violation of Mr. Holmes's rights to due process in this case. So my first request would be that the court restructure the verdict forms in the way that we've proposed. My second request, if the court is not inclined to grant that request, would be to have the jury fill out that Part B interrogatory, regardless of, for every count, regardless of how they, what verdict they render on each individual count. There's no harm in doing that. The court can certainly distinguish and take a look at the verdict forms and figure out, what the result should be in terms of where Mr. Holmes goes. But that's just not a compelling reason to structure the verdict forms in that way. In addition, I would request that at a minimum, the court amend the instructions to make it clear that if their verdict is not guilty of the charged offense and its lesser included offenses, for any reason, including the prosecution's failure to prove sanity beyond a reasonable doubt, essentially at least mentioning insanity at some point during the instruction, telling them how to fill out the verdict form, so that they understand that if they find him not guilty by reason of insanity, they should still sign the not guilty section of Part A of the verdict form. Without waiving our other objections, I think that would at least help make it a little clearer for the jury what they are to do if they have concluded that he is not guilty by reason of insanity. And I guess the last thing that I would add is just because this is a case in which the death penalty is being sought, it's going to withstand potentially years of appellate review. The Colorado Supreme Court is going to have to take an independent look at the propriety of any death sentence, and that's necessarily going to require an evaluation of the actual verdicts rendered. And so I think that the verdict forms need to be very clear on each count whether the jury has found him not guilty by reason of insanity or guilty. And I would make my objections under Mr. Holmes's right to due process, right to present a defense, his right to a fair and impartial jury, and his right to a fair and reliable sentencing proceeding, as protected by the 5th, 6th, 8th, and 14th Amendments, as well as the Colorado Constitution, Article 2, Section 16, 20, 23, and 25.
All right, Mr. Orman. Stand up for this one. All right.
Your Honor, I'm not a big fan of this all or nothing thing for insanity, but that's the law of this state. It's all or nothing. There's no halfway either. That's just the way it is. He can't be insane on part of the counts. We can't have him guilty on some and insane on others. It just doesn't work that way. So these instructions and the verdict form that is presented by this court accurately reflects the law of this state and does it in a fashion that it is easy for the jury to understand. One thing I think is important to note is the court has expressed its plans, and I've never seen a judge not do this in all the trials I've ever done or seen, is that you're going to read these verdict forms to the jury. And the verdict forms in and of themselves are a type of instruction, because the jurors see them and have them read to them while they're sitting in that jury box in the court. You, Your Honor, are reading them instructions. So they're going to have heard already, have read to them already Part B. So they will know. It's not like they're going to get back there and that'll be the first time they've seen these verdict forms and these interrogatories and get back there and have seen Part A and go, oh, gosh, where's insanity? I don't understand how this form is done. So it will be clear to them. They will understand. All the court's instructions are clear. These don't violate any rights of the defendant, and they accurately describe Colorado law and are in accordance with our law.
I thank you.
And Your Honor, that is absolutely not the law in the state of Colorado. The law in the state of Colorado is that the jury can find him not guilty by reason of insanity on any one count and guilty on any other count, that they have to consider each count separately. And in fact, there's another instruction that we went through earlier today that states exactly that. And I would cite the court to People versus Bilecki, in which it states that the defendant contended that there was a portion of the jury instruction in that case. It was a related issue to the special interrogatory form that stated, if the defendant is found guilty of one or more of the offenses charged, he cannot be found not guilty by reason of insanity as to any other offense charged. And the argument there was that amounted to a directed verdict on all counts as to the issue of sanity once the jury found him guilty of any charge. And the Court of Appeals, the Court of Appeals held that they agreed that the inclusion of that language was error. And so it is not the case, as I'm sure the court is aware, that it's an all or nothing proposition. That is not the state of the law in Colorado, and that's exactly what I'm worried about. If Mr. Orman has misunderstood the verdict forms in that way, then what is the jury going to think when they're presented with these forms? Because that's not the case. That's simply not the case. They can find him NGRI on any given count or guilty on any other given count. They have to consider each count separately, and that's why these forms are confusing.
I disagree that the verdict forms are confusing. I think they're really clear, and I think they're as clear as they can be. They are consistent with Colorado law. I don't think Mr. Orman misunderstood the law. I think what I understood he's coming to mean is that while the jury can find the defendant not guilty by reason of insanity of some counts and guilty of other counts, the jury cannot return verdicts on some counts of not guilty by reason of insanity and then guilty on other counts. And that's the law in Colorado. That's, it's one thing to say, well, Judge, the law may be wrong. Well, that may be, but I can't disregard the Colorado Court of Appeals or the Colorado Supreme Court or the Colorado Legislature. In this case, there's authority from all three on this very point. I have the Colorado Legislature telling me this is how it's done. I have the Colorado Court of Appeals telling me this is how it's done. And I have the Colorado Supreme Court telling me this is how it's done. I am in no position as a trial court judge to say they're all wrong and I'm going to do it differently, or to say, well, this is a death penalty case, so I'm going to do it differently. It doesn't work like that. As a judge, I'm bound by the law and I have to follow the law. And the law is, yes, the jury has to consider the defense of insanity with respect to each count separately and independently. And I tell the jury that. That's why I emphasized the one instruction earlier that says exactly that. But in the end, we only care to know about the reason for a not guilty verdict if the jury finds the defendant not guilty of all the counts. Otherwise, we don't care. And that's the law in Colorado. The law in Colorado is, members of the jury, if you find the defendant guilty of even one count, then we don't care about the reason that you may find him not guilty of any other count. All we care about, in terms of those other counts that you find the defendant not guilty of, is that you're finding him not guilty. We don't care if it's because the prosecution failed to prove that the defendant was sane, or if it's because the prosecution failed to prove any other element of that crime charged. We don't care and we don't want to know. That's the law in Colorado, and that's what I have to follow. And this then avoids the situation where you have a guilty verdict, say for example, on the count of first-degree murder, and a not guilty by reason of insanity verdict, say for example on possession or control of incendiary devices. What is the court to do in that situation? Does the court send the defendant to the Colorado Mental Health Institute of Pueblo, or does the court proceed to a sentencing proceeding? And this is what the law, part of what the law wants to avoid, and part of what the law avoids. And what the law says in Colorado is, if he's found guilty of even one count, then we don't need to know as to the reason for any not guilty verdicts in the same case. All we need to know in that situation is that he was found not guilty of some other counts. And that's exactly what my verdict forms and the instructions as they have been drafted do. It is exactly consistent with Colorado law, and it does exactly what Colorado law says. I don't find the verdict forms confusing. I don't find the instructions confusing, and I don't believe the jury will find either confusing. The defense's verdict forms, Ms. Nelson asserted, are simpler or easier to understand. Well, this is not a contest for making it as simple as possible. The idea is I have to make them consistent with the law and then make them as simple as possible. I can't just say, I'm going to do it this way because this is the simplest way, or this is going to be the clearest way for the jury. Forget the law. It's going to be clear to the jury. Or it may be inconsistent with the law, but it's going to be clear to the jury. That doesn't work. And so to the extent that another case that Ms. Spengler may have been involved in did it that way, I'm not going to follow that case. First of all, I'm not bound by other trial court judges. And secondly, I'm bound by the Court of Appeals, the Supreme Court, and the legislature. So in terms of the verdict forms, in Part A, asking only about guilty or not guilty, that's exactly what the model instructions say we should do. And that's exactly what Colorado law says we should do. And so that's what I'm doing. I don't think there's anything wrong with that, and I think the jury will get it. In terms of the final instruction saying that the jury should complete Part A of the verdict forms, if he finds the defendant not guilty, even if the only element that was not proven by the prosecution was sanity, to make it clear that includes the issue of insanity, I don't think that's necessary. I'll take another look at the verdict forms, but I don't see that as being something that's needed. I think that's only going to make the instructions more confusing, not less confusing. And that's not to say that I think there's any confusion in the instructions. I think they're clear, but I think that that risks making them confusing as opposed to making them clearer. Let me see if there's anything else that I wrote down in my notes that I needed to respond to. The separation between Part A and Part B of each verdict form is exactly what Colorado law tells me to do, and is consistent with the model instructions. And by the way, I will read all the instructions to the jury. I will read 5 sample verdict forms to the jury. I will go over all of that with the jury. In addition, counsel are free to go over all this with the jury as well. Counsel are going to have 2 hours to make closing arguments. They can discuss the instructions. They can explain the instructions to the jury to make sure the jury understands them correctly. There's absolutely nothing wrong with that, as long as they do it consistent with the instructions and the verdict forms in Colorado law. And so there's that as well, and I wanted to mention that. So the first, based on my comments, the first request to restructure the verdict forms is denied. The second request, to have the jury fill out Part B of all the verdict forms just because it does no harm, is denied. And the final request to at a minimum make it clear in the last instruction, the final instruction, that if the verdict is not guilty of a charged offense, and lesser included offenses in account for any reason, including because the people didn't prove the issue of sanity, or solely because the people didn't prove the issue of sanity, that the jury should still fill out Part A. Again, I don't think it's necessary. I'll take another look at it this weekend and make a final decision on that, but I don't see that as necessary. I think it's very clear as constituted.
Well, good morning, and like all of you, we are still waiting here in our 7 newsroom for the signal from the courtroom to be established. We're getting a feeling like we did last week, where we were hanging on a string waiting for the judge to enter the courtroom and resume. Last time that this happened, he was reviewing a piece of evidence, I believe, trying to get ready for the decisions he had to make that day, and so we are still in a holding pattern there. And what I wanted to do, since while we were waiting I was working on this, I'm going to scroll forward just a bit and get us into this piece of our timeline. Oh, excuse me, it appears the judge is back, so we'll have to review that timeline later today.
This is the case of the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with 3 of his attorneys, Ms. Nelson, Ms. Spengler, and Ms. Higgs. And the prosecution is represented by Mr. Orman, Ms. Pearson, and Ms. Stitch McGuire. The record should reflect that we are outside the presence of the jury. I have distributed to the parties the latest draft of the instructions and the verdict forms. So let's talk about those first, if we can. Yeah.
I have a motion with regard to Colorado Rule of Criminal Procedure 15. If I could make that briefly on the record before the court gets into the jury instructions. I have notified Mr. Orman that I would make this motion.
I would rather talk about the instructions first. So let's talk about the instructions. All right, the newest draft reflects some of the changes that I made over the weekend. And so I want to make sure that council have had an opportunity to review those, and if they need more time to review them, then, I'll take a break and council can review them further. But I think what makes the most sense is to go through them in order. And I'm not going to mention any changes as to form, but only substances. And I don't think there were that many changes as to form. But on the first instruction, I made the change that we talked about on page 2. At the top of the page, Ms. Nelson asked that in that last sentence of the first incomplete paragraph that I change by the end of August to read at the latest at the end of August. And so that change has been made. Do you see that? Okay, Ms. Nelson, do you see that?
Yes, Your Honor. And I just wanted to let you know, I made it as far as the instruction on the affirmative defense of insanity before the court took the bench. So
Okay,
I haven't
that's
had a
fine.
chance to look at anything beyond that.
Okay, that's fine. All right, the next one, the next change I made is with respect to the last page of that same instruction. And this one, I made it on my own because I thought it made sense to make it. In the penultimate paragraph on that page, at the end I added a sentence that says, similarly, if I sustain an objection to a question after a witness had already provided an answer or partial answer, you must not consider any part of that answer in your deliberations. That's not in the model instruction, and it wasn't in the draft instruction that we were working with as of Friday. And so I thought that it made sense to include that in there. I have instructed the jurors throughout that about this specific point. And I know that there was a point when I felt like Ms. Spengler started asking to strike answers to sustain objections over and over, and I decided to deny the request because I don't think I didn't think it was appropriate. So, but I told the jury, members of the jury, you know that if I sustain an objection, it means that you should disregard any partial answer or full answer provided. And so I've been telling them that throughout, and I think it makes sense to include that point in these instructions. Is there any objection from the people?
No, Your Honor, thank you.
Is there any objection from the defense?
No.
Okay. The next instruction that has a change from Friday's draft is the instruction that starts with, in this case, a separate offense is charged against the defendant in each count. And all I did on this one is I added a comma. Now, I know that's not a substantive change. I'm mentioning it simply because I mentioned it on Friday, and I know that both sides were okay with that because I asked them on Friday and they told me they had no objection. The very next instruction was changed at the people's request without objection to reflect or to make it consistent so as to use culpable mental state, and that's what it reads now instead of state of mind. And in fact, there was a place, if you see on the third full paragraph.
Your Honor, I'm sorry to interrupt, but I think that one has perhaps been moved to be later in the instructions. Is that what?
Yeah, you're right. The order has been moved, and I said I would move it. Thank you for reminding me. I moved it to after the elemental instructions, and I said that I would move it, but the changes should have been made. So check that if you would. And I'll give you a chance. I'll take a break, Ms. Nelson. I'll give you a chance to get through all of them, but that change should have been made by now on that one. I was saying that on the third paragraph, the term that is used or that was used in the draft that we were working off of on Friday states or says state of mind, not culpable state of mind. I went ahead and just changed it to culpable mental state, again, just to be consistent throughout. So,
The only thing that I'm noticing is there's a brief sentence with a colon that goes before the bullet points, and it talks about the applicable states of mind.
oh, okay, I missed one then. Okay. Give me just a second. Which paragraph is it?
Well, technically, I think it would be the fourth, Your Honor.
Oh, here it is, the applicable culpable mental states. Thank you for catching that. I'll change that.
So is the court changing it to applicable culpable mental states or mental states?
Culpable mental states. And I think it makes sense to be consistent throughout. So any objection to that, Mr. Orman?
No, Your Honor.
Any objection, Ms. Nelson?
No objection, Your Honor. But I did notice that, and I know we talked about moving this instruction to come after the elemental instructions.
Yes.
But then I also noticed that we still have the instruction that provides definitions for other words and phrases like deadly weapon, firearm, explosive, or incendiary device before the elementals. And so my request would be that we either do all of the defining of terms before or after. It just seems a little odd to me to define some of the terms that they're going to hear about in the elementals before, but then not define the culpable mental states until after.
Well, but the culpable mental states, it's not just a definitional instruction. It's talking about the the mental states that are elements of the offenses. So I think it makes sense to have that one come after the elemental instructions, because otherwise they won't know why we're including reckless in that instruction. In terms of the definitional instruction, it doesn't bother me to have it precede the elemental instructions. And in some ways, I think it's helpful because when they see the terms come up in the elemental instructions, and some of these terms will come up in the elemental instructions, they will already have a definition. But I don't feel strongly about it one way or another. Do the people have a position, Mr. Orman?
No, Your Honor.
Give me just a moment, Ms. Nelson. I don't have a problem moving it, Ms. Nelson, so if you prefer to have me move it, I'll move it to right after the elemental, actually, I think it makes sense to have the culpable mental states come immediately after the elemental instruction, so I'll move this one right after that. Is that okay with you?
Yes.
Okay. All right. The next instruction that has any changes is, let's see here. Is the insanity instruction. And before that one, the theory of defense instruction has been included now. So let's talk about that one at the end, okay? So let's pass that one for now. So don't let me forget to talk about that one, or to come back to that one. But the one that talks about the defense of insanity, I changed it at Ms. Nelson's request in page 2. I think it's on page 2, I should say. So now in the first full paragraph on that page, the second sentence reads, in order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt both of the above numbered conditions with respect to the act alleged in the charge offense in each count and in each of the lesser included offenses of that charge offense. And then I have deleted the last sentence that used to be there because I agreed with Ms. Nelson that that last sentence was repetitive, especially given the modification to the sentence that I just read. I considered whether to change above number conditions based on the objection that Mr. Orman had. And for a while there, I thought that we could say both of the number conditions stated earlier or listed earlier in this instruction. The problem with that is it makes it more wordy, and then it makes it, I think, a little more difficult to follow. So I think it'll be clear what both of the number conditions, above number conditions, refers to. So I ended up deciding that it was not unnecessary and that it made the instruction less clear as opposed to more clear. The next instruction that I changed is the very following instruction that deals with the phrase incapable of distinguishing right from wrong, as used in this instruction, refers to a person's cognitive inability due to a mental disease or defect to distinguish right from wrong as measured by a societal standard of morality, even though the person may be aware that the conduct in question is illegal. It used to read like that, and now the change is that it says criminal instead of illegal. I did that because I went back and reread People versus Serravo, Serravo, 823 Pacific 2nd, 128, Colorado Supreme Court, 1992, and also People versus Gallimanis, 944 Pacific 2nd, 626, Colorado Court of Appeals, 1997, and Gallimanis is spelled Gallimanis. And after rereading the relevant portions of both cases, I became convinced that I should stick with the language that those cases used and not my own language. And so I went ahead and changed that to criminal. That's, I understand over the defense's objection, but I think it's the appropriate way to proceed. So that change I wanted to point out to you because we had not talked about it on Friday. That's a change that I made on my own after going back and reviewing those cases. And just for the record, Ms. Nelson, I understand that you object to the use of that particular term. I understand that your preference would be to use the word illegal, and initially I had agreed with you. But setting that aside for a moment, you are asking that I give this particular instruction. Is that correct? And I ask because, as you know, that this instruction is not required. Mr. King requested it during the trial. The people, I think, said that they didn't think it was necessary, but I went ahead and gave it based on the request by Mr. King. So I'm assuming you want this instruction, right?
Yes, we do, Your Honor. And I just want to make sure that I constitutionalize our objection to the change under the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, as well as the Article 2, Section 16, 20, 23, and 25 of the Colorado Constitution.
Okay, thank you. All right, the next instruction that changed is the informational instruction. So that's the very next instruction. And again here, before we talk about the change, I want to make a record that the defense is asking me to give this particular instruction. The case law in Colorado, as I understand it, says that upon request by the defendant, this is an instruction that I should give. And let me just quote the actual language from People versus Thompson. That's Thomson. Thomson. 197 Colorado 232, 591 Pacific 2nd 1031, Colorado 1979. That's a Colorado Supreme Court case. There, the court adopted the rule that a defendant who is relying on an insanity defense is entitled, upon request, to an instruction on commitment procedures. And so when I, this weekend, did some research on this, and I read some of the cases that have cited and relied on Thompson, first of all, it is clear to me that the court simply wants to make sure that the jury is not misled, or that the jury does not misunderstand or does not speculate about what happens if the defendant is found not guilty by reason of insanity. And the court's rationale was, most lay people understand what happens if someone is found not guilty in a criminal trial. They get that the person gets to walk out. They're acquitted. Most lay people also understand what happens if they are found guilty in a criminal trial. They understand that the court then has to impose punishment. But most lay people are not aware of what happens when someone is found not guilty by reason of insanity. And the court's concern is that jurors may speculate, and as a result of speculating, there may be a miscarriage of justice. For example, if a juror thinks that a not guilty by reason of insanity verdict results in the defendant walking out of the courtroom, the jury may be more inclined to find him guilty. And that's what the court is trying to address. And so the court said that if the defendant requests an instruction on commitment procedures, that the court should give the instruction. It is clear to me that the court was not envisioning having the trial judge give a law school lecture on what happens in case someone is found not guilty by reason of insanity, but rather a brief statement related to commitment procedures, related to what happens in the event that there's a not guilty by reason of insanity plea. And that's what I'm trying to do. But then I went and looked at the statutes to make sure that we were being accurate. And a couple of things. Number one, based on Section 16-8-105.5. Subsection 4, I added the word custody. And I know that the defense had made a request wanting to convey to the jury that this isn't just a regular hospital, but that the person is being held in some sort of custodial type of arrangement. And I had denied that. I don't know whether the defense had actually used the word custody, but if you look at subsection 4, what the law says is that if the trier of fact finds the defendant not guilty by reason of insanity, the court shall commit the defendant to the custody of the Department of Human Services until such time as the defendant is found eligible for release. And then he goes from there to talk about more details, and I know that the defense had included some of these details in one of the tendered instructions that they submitted. And it talks about the executive director of the Department of Human Services shall designate the state facility at which the defendant shall be held for care and psychiatric treatment, and may transfer the defendant from one facility to another if, in the opinion of the director, it is desirable to do so in the interest of the proper care, custody, and treatment of the defendant, or the protection of the public or the personnel of the facilities in question. And, you know, the question that comes to mind is how much detail is appropriate? And if I give this, then there may be other detail that a party may want, and there may be other detail that then I can possibly give as well. And I don't think that the idea is to give as much detail as possible. The idea, as I understand the case law, is to provide a brief statement about what happens in the event that the jury finds the defendant not guilty by reason of insanity. But in any event, I added the word custody, which wasn't in the instruction before. Additionally, I modified the language in the instruction based on what I believe is the applicable test for release. And counsel can correct me if I'm wrong, but I looked at Colorado Revised Statute Section 16-8-120, which is titled Applicable Test for Release. So subsection 1 applies to any person charged with any crime allegedly committed on or after June 2, 1965. Subsection 2 applies to any person charged with any crime allegedly committed prior to June 2, 1965. So certainly subsection 2 has no application here. Subsection 3 applies to any person charged with any crime allegedly committed on or after July 1, 1983. And then subsection 4 applies to any person charged with any crime allegedly committed on or after July 1, 1983, but before July 1, 1995, that resulted in commitment by reason of impaired mental condition. So 4 doesn't apply either. And so the two possibilities are subsection 1 and subsection 3. It seems to me that because this is a case that relates to a person charged with a crime allegedly committed on or after July 1, 1983, subsection 3 should apply. And so I have used the language in terms of the test for eligibility that appears in subsection 3. And it reads as follows. It says, as to any person charged with any crime allegedly committed on or after July 1, 1983, the test for determination of a defendant's sanity for release from commitment or his eligibility for conditional release shall be that the defendant has no abnormal mental condition which would be likely to cause him to be dangerous either to himself or others or to the community in the reasonably foreseeable future, and is capable of distinguishing right from wrong and has substantial capacity to conform his conduct to requirements of law. So that's what that language is now reflected in the instruction, with one exception. I took out the reference to sanity because I don't want to confuse the jury. I don't want the jury being confused between what the test for sanity is in this trial and what the test for sanity would be in the event that we are dealing with eligibility for release after a not guilty by reason of insanity verdict. So that explains the changes to this instruction. One other change that I made to this instruction is that I deleted the reference to Arapahoe County District Court. I felt that it was clearer to make the instruction, at least part of it, personal to the defendant or individualize it to this case, and therefore just left the court, as opposed to talking about just a defendant, at least in that beginning of the second full paragraph of the instruction. I think that the last sentence of that second paragraph, it is okay there to talk about general terms, because I think there is just setting forth what the test is. But I think the first sentence is informing the jury what happens if this defendant is found not guilty by reason of insanity. So that's why I changed it, and it appears the way it is. Given my change to make it individualized or to make it apply to this case, it didn't make sense to leave the Arapahoe County District Court in there. The last thing I have is that the language that used to be in this instruction, which I know came from the case law, it came from Thompson. You know, in Thompson, the court didn't say, here's the language that we think the trial courts should use when giving this informational instruction. What happened in that case, as you folks may remember, is that the trial court had used an informational instruction, and the court had to pass judgment as to whether that instruction by the trial court was appropriate or not. And the court said, yes, it was appropriate, and it was a good thing that the trial court gave it. And then the court said, in addition, it should be preceded by a sentence that says this is an informational instruction and must have no persuasive bearing on the verdict that you arrive at under the evidence. And so that line has been added. But I don't know that as a trial court, we're glued to the specific language in the instruction that was before the court in Thompson. And I think we have to be, it seems to me, we have to be consistent with the law in Colorado today in terms of the test that applies for eligibility for release. And I think the language that used to be in here before comes from, as far as I can tell, Colorado Revised Statute, Section 16-8-115, subsection 1. But what that statute talks about is when the Department of Corrections submits a report to the court related to eligibility for release, not the test applicable for eligibility to be released. The test applicable for eligibility to be released is articulated in the statute that I cited, 16-8-120, subsection 3. So, all right, having said all that, I don't know if you want a chance to be heard further on this or not. Do the people have anything else on this instruction, Mr. Orman?
We agree with the instruction, Your Honor.
Okay. Does the defense have anything else on this instruction, Ms. Nelson?
I would like the chance to review this in a little bit more detail if the court would allow us to do so at a break, just so that we can compare the language with the language that we submitted in the statute. I just didn't have it. I didn't get to this one before the court took the bench.
You bet. I'll take a break and I'll give you a chance to do that.
Thank you, Your Honor.
The last instruction that changed that I wanted to talk to you about is the last instruction in the draft. And this one changed based on Ms. Nelson's request. In one way, based on Ms. Nelson's request. In another, based on Mr. Orman's request. The first change that I wanted to point out to you is on the first line. Instead of saying following the parties' closing arguments, I think it's more appropriate to say following the attorney's closing arguments. And so I've changed it that way. But the next change, or the next changes come on the second page. You'll see that in the second full paragraph, now it reads as follows. As mentioned earlier in these instructions, each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately and influenced by your decision as to any other count. Therefore, the fact that you may find the defendant guilty of the charged offense or a lesser included offense in a count should not control your verdict as to the charged offense and lesser included offenses in any other count. Similarly, the fact that you may find the defendant not guilty of the charged offense and the lesser included offenses in account should not control your verdict as to the charged offense and the lesser included offenses in any other count. This is the case even if the reason that you find the defendant not guilty of the charged offense and the lesser included offenses in account is solely based on the prosecution's failure to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act. Having said that, if you find the defendant guilty of any charged offense or lesser included offense in any count, you should disregard Part B of all the verdict forms. You should answer the verdict question in Part B of the verdict forms only if you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case. The verdict question in Part B of each verdict form asks whether the jury found the defendant not guilty of the charged offense and the lesser included offenses solely based on the defense of insanity. Pursuant to these instructions, you will either complete Part B of all the verdict forms or you will disregard Part B of all the verdict forms. So that paragraph that starts with as mentioned earlier in these instructions was added at Ms. Nelson's request to make sure it is clear that the jury understands that their verdict on one count does not bind or affect, influence their verdict on a separate count. Then the changes in the following paragraph in terms of underlining and making it a bold font for certain words was based on Mr. Orman's request. I didn't think it was necessary on Friday, but given that I'm adding this other paragraph, I felt that it was necessary to make sure they understand that they are not to concern themselves with Part B of any of the verdict forms unless they find the defendant guilty of all the charged offenses, unless they find the defendant not guilty of all the charged offenses and all the lesser included offenses. I think that given the paragraph that I added at Ms. Nelson's request, I think it is appropriate and necessary to highlight for them or to emphasize for them the only time when they fill out the Part B of all the verdict forms. And then I added the parenthetical in that last paragraph that I read, based again on Ms. Nelson's request, to make sure the jury understands what Part B of the verdict forms relates to. And then to be consistent, I did the same 2 paragraphs later with respect to Part C of each verdict form. I added a parenthetical. Now, I know, Ms. Nelson, you haven't had a chance to review it, so during the break, I'll give you a chance to do that, okay?
Yes, thank you, Your Honor. And I just wanted to make sure, I agree that we did have some discussion about making some clarifications and additions to this instruction. I also just wanted to confirm that the court did receive the pleading that I filed with, after court on Friday, I concluded that I needed to give the court some more specific language, and so I did submit proposed revisions of my own this morning in D-292.
Yeah, and D-291 or D-292? I have D-291 in front of me.
D-292. 291 was just the resubmission of all the original charges as well as the supplemental instructions with numbers, but D-292, which I emailed to your staff and the prosecution last night, contained actual proposed revision to the specific proposed revisions to a number of the instructions that reference the verdict forms.
I haven't seen it. I have D-291 in front of me. I don't know what D-292 says. And frankly, I was going to get to this, but D-291 is stricken as improperly filed. What I said you could do is you could renumber your tendered instructions. I didn't say that you could file a pleading that contains argument and record. So this is stricken. If you want to refile the instructions that you have tendered by numbering them, you can do that. I've given you leave to do that. If you want to make a record with respect to anything else, you have to make it here in court. So this is stricken, and I'll issue an order striking it. What we're going to do is we'll take a break, and I'll give you a chance to figure out what oral record you want to make in terms of what was in this improperly filed pleading, and I'll give the people an opportunity to respond, and then I'll rule on any request that you have, okay? All right, is there anything else before I take a break with respect to the instructions?
Your Honor, not with respect to the instructions. At some point, I would like to approach the bench to make a record about a sensitive victim issue whenever that would be accommodating for the court. Thanks.
All right, first I want to finish the, talking about the instructions. Oh, the theory of defense instruction. I'll give Ms. Nelson a chance to review it, but the record should reflect that pursuant to the law, I took the instruction that was tendered by the defense, which I concluded was improper, and that's because it sounded more like closing argument than a theory of defense instruction. I did my best to capture the essence of the theory of defense instruction, and I have redrafted it then and included it in the set that I gave the parties. I'll give you a chance to review it, and then Ms. Nelson, you can tell me if you would like me to modify anything without waiving your tendered instruction. If you have any objections to any words that I've used, I've tried to use the words that you used, other than to make it clear that these are the assertions of the defendant and not statements by the court. Those words that reflect that aspect of the theory of defense instruction that I drafted are my words. For example, the defendant asserts or claims or contends or avers. Those are my words, and I've tried to be clear that these are the defendant's assertions. If you want me to change some of those words, let me know, and I'll happily change them. I've tried to vary it so it's not repetitive, so we're not saying asserts over and over and over again. But if you would prefer to just do asserts over and over, I'll do that. If you have any particular objection to anything that I left out that you think relates to the essence of the theory of defense and is not argument, then you can tell me that. If you would like me to modify anything or add anything, you can tell me that. If you would like me to take something out, you can tell me that. But this is my best effort as to what an appropriate theory of defense instruction should look like, given what the tendered theory of defense instruction contained. So we'll take a break. I'll give you a chance to do that, and then we'll proceed. Mr. Orman.
Just one question, Your Honor, regarding the verdict forms. You've
Yes.
given us these sample verdict forms, and we've checked them, and there doesn't seem to be any issues with them. At some point, though, I think we're going to need to get all of the proposed verdict forms just so that we can check them, and because I know the court would want us to do that. And I was just wondering if there's a plan for that.
We will, my staff will email them to you, but I don't know when that's going to be. That's going to take a lot of time. I can't do that unless we finalize everything first. And so I want to make sure everything is finalized, and then, given that it's 165 of them, we better make sure that they are final. So, and we'll email them to both sides. I know that the parties had asked, and I think specifically the people, for an email version of the latest draft, and I will give you that. Keep in mind that this will not have the blanks filled in, because if you want the ones that show the blanks filled in, then we'll have to scan those. And it sounded like you didn't want them scanned, you wanted them on Word. So if you don't care about the blanks being left empty, then that's what you both will get. And then you'll get the final copies tomorrow when you get here with all the numbers filled in.
Thank you, Your Honor. That makes a lot of sense.
Okay, all right, we'll take a break. That'll give Ms. Nelson a chance to review some of the things that I have talked about, and then we'll proceed. The court will be in recess. Thank you.
Your Honor, how long
Yes.
are we taking?
How long do you need?
Half hour, 45 minutes?
Fine,
Is that
whatever you
okay?
need.
Okay, and would the court, I was not aware that the court had not received my proposed revisions in D-292. I have a copy of them if the court would like to see them.
Well, which ones have been revised?
The proposed revisions, if the court recalls, as we were going through the instructions, I kept
Right.
saying that I had objections to the part of the elemental instruction that referenced the verdict form. And so there are proposed revisions, fairly short revisions to each of the elemental instructions, as well as to the instructions that discuss the verdict forms. So
I think you've made your record. I mean, my concern is I will not have time to review these instructions. We're talking about instructions now. You've had plenty of time to submit them. These are late. If you want, you've made your record as to what your objection is. If you want to, I'm not sure what exactly these have that you haven't made a record on already.
it's very specific language, Your Honor, and I felt after the instruction conference, I made a general argument about the problems that I see with the verdict forms, and I asked the court generally speaking, the court kept saying, remind me, it's on you to remind me to go back to these particular instructions. And I didn't propose word for word specific language that I was requesting be changed or added to the elementals. And so after Friday's conference, I spent the weekend thinking about it and decided that in order to provide Mr. Holmes with effective assistance of counsel, I needed to make sure that I made it abundantly clear to the court exactly what I was asking from the court. Obviously, we had the charging conference on Friday, and it's now Monday morning, so that's why I took the liberty of emailing an advance copy of this pleading to the court staff as well as the prosecution last night, and I had our paralegal file it with the court at 8:30 this morning. So
Well, what we'll do is we'll go through them one by one, and you can tell me what you've modified, and then I'll consider it, and we'll go from there, okay?
okay.
All right, the court will be in recess. Thank you.
If I could make a request,
Yeah.
is there a time that the court would like me to come back to address issues with regard to scheduling for penalty and our motion under Colorado Rules of Criminal Procedure?
Whenever we're done with the instructions. I want to get the instructions done first. So that's mostly up to Ms. Nelson. I don't know how long it's going to take her. And then I don't know how long it's going to take us after that. So it's hard to say. So we'll do the best we can. Okay, the court will be in recess. Thank you.
Good morning again. Phil Tenser here, joining you from the 7 News newsroom as we take this break of indeterminate length, 30 to 45 minutes, as they said there in court. But we are making, it seems, significant progress now on these jury instructions that will allow us to get these closing arguments done tomorrow and the jury to begin deliberation. And so a few moments ago, I asked you to give me some questions since we had this long recess. And several of you have asked questions about the commitment procedure, if he is found not guilty by reason of insanity, where he would go. And so let's start with that system. Andrew, if you could, would you please punch up the computer screen here? And let's take a look at this again. We've seen it many times before, but the affirmative defense of insanity, this is the model instruction, the draft instruction that the process we're going through right now is modifying. But the key are these two lines here that I've just highlighted. That the jury needs to decide, and this is what the judge said is going to be on Part B of the deliberation forms, the verdict forms that the jury will be handed for all 165 counts, that if the jury finds the gunman is not guilty by reason of insanity, if the jury finds the gunman not guilty of the count, the next question is, was it due to insanity? And then they have to decide that the prosecution did not substantially disprove beyond a reasonable doubt either of these 2 points, that the gunman was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act, or, and big point here, it is an or statement, that the gunman suffered from a condition of mind caused by mental disease or defect that prevented him from forming a culpable mental state that is an essential element of the crime charged. So, if they go through Part A, find him not guilty, Part B, explain that it's because of insanity, what would happen if all of these counts are found not guilty by reason of insanity? And the judge should point out the jury could find some are not guilty by reason of insanity and some aren't, but let's assume it's all or nothing proposition. If they are all not guilty by reason of insanity, the judge was just discussing this informational instruction on commitment. This is an informational instruction that has no persuasive bearing on the verdict. Now, the judge has made clear that he is going to modify this, discuss it. He talked about whether he would include the name of his own court as the decision-making body, and of course, whether he would include that legal standard that you won't see on this page that begins with the idea, and I'm trying to find it here in my notes in the background, but the judge had a quote that is the decision-making factor. The defendant is found, and this would be in the future after some period of commitment, which is an indefinite period of commitment. The defendant has no abnormal mental condition that would likely cause him to be dangerous to himself or others or the community in the foreseeable future. So when this says no longer requires hospitalization, the judge is discussed adding that sentence from the statute that I just read to you aloud. Now, if he's committed, where is he going to go? And many of you have had questions about this. And so let's look at the map here. This is Google Maps over Pueblo, Colorado. So just to give you some bearing, Colorado Springs, Denver here to the north. The crime itself occurred over in this area where Aurora is highlighted. But down here, probably about 130 miles or so, Pueblo, Colorado. And let's zoom on in. And you'll see this pink L-shaped square. This is the very large, considerably large campus of the Colorado Mental Health Institute at Pueblo. And so I can tell you from having driven in this area, it is a very large campus. There are several hospital-like buildings here, but what I want to do is I'm going to drop the little Google man here on 24th Street and show you this part of the complex that's much more prison-like. And I can't say with any certainty that this is where the gunman would actually be held, but you can see this looks like, if you're passing it and you don't know it's a mental hospital, it looks like a prison. Double-layer fences, security, tiny windows, and it is a substantial size here. Let's see if we can move down the road a little bit and get you another view. But, you know, the yards are double or triple fenced. I mean, it is a very significant facility, and this is only a portion of it. Of course, there is the hospital section of it. Let's see if we can take a look at that as well and show you what looks like a hospital here. Of course, the Google car did not drive through this and take pictures, but you can see these buildings here in the background at a distance and here up close are hospital-like, to me at least, and certainly we don't know where in this facility the gunman would be held, but it would make sense, obviously, for it to be in that high security area, but then the possibility remains for treatment in these hospital-like areas. So just to review and explain that to you, this is here on the northwest corner of Pueblo, Colorado, a good probably 2-hour drive south of Aurora, here along Interstate 25, zapping up through Castle Rock and then into the Denver metro area where the crime itself occurred over here in Aurora, at the Century 16 Theater at the Aurora Mall. Let's see, can we, Andrew, let's come back on screen. Let's answer a couple more of these questions here since we have the time to do it. Is there any minimum time required for commitment in the state of Colorado? And the answer is no. As we saw on that previous screen, it is entirely up to the judge and that piece of the statute that says he's no longer of a danger. And we have certainly done reporting before this trial started. During the jury selection process, we've done reporting about people in the state's history who have been found not guilty by reason of insanity and then later released. But in those cases, it was several years, although it is not in any way written down in Colorado law that this must happen in a set period of time. It is entirely up to, in this case, Arapahoe County Court and the chief judge of the district, in this case, Judge Samore, but who knows if it is 10 or 15 years in the future, who knows who the chief judge will be at that time. So it will be up to that court to determine it. It's not up to another court. It's not like he can bring it to a Pueblo County court just because he's being held very likely at a place in Pueblo. It's up to the court that committed him to go there. Let's see if I scroll down here with a few other questions for you. Who else is housed there that we would know? And Tammy, I don't have an answer for you there on that question, but it certainly is a big facility. Cricket, can he be found just plain old not guilty? My understanding is that there is a legal technicality that is technically possible, Cricket, but absolutely not likely to happen. I mean, the not guilty by reason of insanity is what's called an affirmative defense, meaning it is akin to saying, I did it, but here's why it wasn't my fault. Being found not guilty is not a reasonable option that we should entertain in our discussions. DKF asking, if he's found not guilty by reason of insanity, will there be a sentencing phase? And the answer to that question is no. There's only a sentencing phase if he's found guilty, and at which point, under Colorado law, since this is a capital sentencing case, or capital sentencing is being pursued in this case, we have to go to a sentencing hearing. Now, how long will that last? We don't know, but there would not be any at all if he's found not guilty by reason of insanity. That would result in the immediate commitment to human services and very likely that mental health institute at Pueblo. If we get to sentencing and victims come to testify, how long do they get? Is there a feel for how many will choose to speak? And Tammy, that is an interesting question. We don't know much about this. All I can tell you is that at one point early in this process, we heard that it could take a month for the sentencing process to go through its entirety, with all the hearings and all the witnesses and victim impact statements that they want to present to the jury. And also the defense, remember, gets to present their mitigating evidence. So they've talked about wanting to fly in some of the gunman's friends or family from California to speak. Certainly we've not heard from his family in the past. The opportunity for that to happen would only be during the sentencing hearing. So while I can't say how long each person gets, I've not read anything that states this person gets a half hour and this person gets a half hour or anything like that. That has not been written down or legislated in any way by this court. But we do expect the whole process to last about a month. Mark, can the jury request to rewatch any of the prior testimony? And that's an interesting question, because certainly you or I could go rewatch it. We've archived it all for you. The jury, however, doesn't get video. They get the recording. So, recording, the recorder's notes, the written testimony as it was recorded by the court recorder who sits there in front of the judge. You'll see sometimes he or she wears headphones to hear things more properly through the same audio system that we are hearing through. But the court recorder's notes will certainly be available to them. The evidence will be available to them, but an interesting note that the judge made last week, they might get a DVD of evidence, but they're not being given necessarily the equipment to watch it on. So they have to request when they want a DVD player, for example, to watch that piece of whichever jail video or Dr. Reed's examination that they might want to rewatch. So that's an interesting question, but certainly something that they won't be able to watch the video feed as we've had it. They won't be able to re-see the video or hear the inflection in the voice. They're going to get to see it in its written form if they ask for it. What is the toughest sentence that the gunman could get other than 100% guilty on all counts? And LG, that question is quite in depth. The best way to answer it, I would say, obviously the toughest sentence would be the death penalty. But if on all 165 counts the gunman is found guilty only of the lesser included offenses, there would still be a massive range. I mean, if you imagine that, let's just take the 24 different counts of murder, 2 for each of the 12 victims. If all of those include manslaughter and each of those has several years attached and he's found guilty of manslaughter for some reason in this, then it would be up to the judge and the jury to decide not only that, but are these going to be concurrent sentences or are they going to be consecutive sentences? Concurrent meaning that they overlap and so he can serve 1 year on each of the counts at the same time, for example. Consecutive means that they would be served end to end. So 3 years, say, for each of the manslaughters, or 7 years for each of the manslaughters, would add up very quickly since there would be 24 of them. And that would end up to what would still be equivalent to a life sentence. So that said, I don't think it's very likely, and certainly our legal experts have not said it would be very likely for any of these lesser included offenses to be realistically reached. It's going to be a decision between guilty of the charges as they are or not guilty by reason of insanity. In all intents and purposes, that's going to be the most likely result, one of those two decisions. Dissecting the various charges and breaking them down, I don't think is very likely. Kathy has asked, how likely is it that the judge will delay this trial to allow character witnesses to be available? the defense may have said that some wouldn't be available in time, and that is certainly possible, as we are still ahead of schedule, even though things have been back and forth a bit on when we're going to have closings. We are still ahead of schedule. But remember that this is a month-long process for this hearing, and so it could be rearranged, and I don't think there will be much of a delay at all, especially considering the jury's going to take a couple days, very likely to reach a verdict, and then we're going to have probably a day off or maybe a weekend, depending on when they reach this verdict, before we go into the sentencing hearing itself, and that has 2 phases, and so the result is we are still going to get into August if he's found guilty and if we go to a sentencing phase. I'll take a second here and try to take a look at the YouTube chat before we wrap this up. Jen, I'm not sure what... oh, I see. Jen is asking guilty but not death penalty, and that certainly is a possibility. It could be guilty but life in prison, and it is important and interesting to point out that in Colorado there are only a handful of people on what you might call death row, even though there's not a designated place of that kind in the state of Colorado. All of them are from this one county, Arapahoe County, where this trial is taking place, where 164 of the 165 counts took place, the last one being the incendiary devices charges, which technically was in Adams County, but has been allowed to be tried as part of this case in Arapahoe County, and where Judge Samore is the chief judge of the district, sitting there in his Division 201 on the second floor of the Arapahoe County Courthouse in the biggest courtroom that they have there. But the question is, could it be the death? Could he get guilty but not the death penalty? And that certainly is a possibility. It's interesting to keep in mind that context, though, that this county is the only county that in the last couple decades has put someone on death row. Has anyone currently awaiting the death penalty? And I think the count is 3 people awaiting the death penalty from that. And of course, you got to keep in mind the political climate of the state right now. On the flip side of that, even though this county has put people on death row, even though they have a Republican district attorney, the last time that someone was ready for the death penalty, our governor, who was just recently reelected and is now in his second 4-year term, Governor Hickenlooper did put an indefinite stay on Nathan Dunlap's execution. And so even though he's still technically awaiting the death penalty, it's going to be up to a future governor whether it gets imposed or whether this indefinite stay of execution will remain. Heather asking, what does it mean that there are multiple layers of the sentencing phase? Does it mean like another trial? And Heather, it is like another trial, but my understanding is that there's actually 2 rounds of this. And the judge is talking about, in past hearings, who goes first and in each round. And so there's going to be victim impact and mitigating evidence and things that all have to be presented. The order of that is a little bit unclear to me, but it is something we should discuss with our legal experts later today, and I will make a point of writing that down. Deb, if the jury is hung, how long before a retrial? That's a question I would I could never know the answer to. I'll tell you what, let's do this, Andrew. Let's flip over to the computer for a moment. And while we do that, Cricket, I do want to respond to your question that, yes, we will have the closing arguments in their entirety on the 7 News app and the denverchannel.com. We'll send out alerts and everything when it begins. On television, there will be some updates throughout the day in the form of tickers and potentially some commercial break length updates. But it won't be an entire day ordeal because we simply don't have enough hours in the day to do all of that work. But now here we are. Let's go back to this question about how long this could take to do a retrial. Deb, if we look at the process as it's been so far, technically the jury selection began on January 20th of this year. Technically, that's when the trial began. So even though we talk about 48 days now of the trial itself, and you can't see me here, but I'm doing air quotes around the trial. The trial's been much, much longer than just 48 days. It's lasted since January 20th, when the first phase of the selection process began. Now, as we jump through it, there were other things happening, including this plan, development of the plan for voir dire, which is the selection of the jury. Then finally, the first, of the 9,000 that were sent out, 7,000 were received. Several thousand showed up for the first phase of questionnaire. And then there was individual questioning, which began in February. They had phase 2, other things occurring, the mother publishing her prayer book on Amazon. Finally, the opening statements are scheduled. It's an old photo. Parents giving an interview, all of this occurring. Lawsuit against the theater set. Finally, phase 3 didn't begin until April 13th. And of course, the trial itself began with 19 women and 5 men. We're now down to 19 total. Jury question, the questionnaire was released after several months. Finally, the opening statements began on April 27th. So we've gone from January 20th to April 27th just for the jury selection. So when you ask about how long they might take to start over, my gosh, it's going to be quite a long process because they have to do all of that selection again. This was one of the largest, if not the largest, jury selection process in Colorado history, lasting from January 20th to April 27th. And then the trial itself, of course, is one of the longest in state history, beginning on the 27th and going day by day by day through. Now we have, we're on the 48th day of what we're calling the trial. But that would mean 45 days of testimony. And of course, most of the weeks were only 4 days long. So as we advance through this, let's take a minute and look at how many people, and by the way, this timeline is available on your 7 News app or thedenverchannel.com. And so what I've done and what I've actually just been updating earlier this morning was putting in video highlights from each day of our 48 days of the trial so far. And so you'll start here, and that is certainly not all of the videos between Anika and Brian and myself. We've cut, I think, 160-ish various videos from the days of this trial, and I've just picked 1 or 2 from each day to put on this timeline so that you could breeze through it and get an idea, catch up quickly if you have missed any days. But so, of course, we started on the very first day, Caleb Medley and his wife taking the stand. Caleb, you'll remember, was gravely injured and was only able to answer a few brief questions with yes answers and pointing out the letters on a board to confirm what he was trying to communicate. Joshua Nolan testifying on the 29th about being taken to the hospital from there, from the theater, that is. Officer Aaron Blue being told about the improvised explosives as we were developing this case here. The prosecution, that is, developing their case. A shooting range worker describing seeing the gunman. This was one of the things that we had never heard about prior, something that we'd heard about just for the first time during the trial itself. Brandon Axelrod talking about what he remembers from inside Theater 9. Amanda Teves testifying that she didn't want to leave Alex behind. Alex, of course, one of the 12 who was killed. Caitlin Fonzie talking about hearing the music, going up to the door, almost opening the door to that apartment in 1690 Paris Street. This was an emotional moment because she remembers just coming within inches of triggering those traps, and of course later found out what they were, what was behind that door. FBI Special Agent Christopher Rigopoulos testifying about what he did find behind the door of 1690 Paris Street, apartment number 10, testifying that it involved booby traps, incendiary devices, things rigged to blend chemicals together to start fire, oil and gasoline soaked into the rugs and in soda bottles. Testimony from CSI team counting evidence of 76 rounds fired inside the theater itself and hundreds more of unspent cartridges and rounds. Jamie Roars testifying about his fleeing the theater, how he got separated from his family. At this point, we're on May 14th. Dion Rossborough talking about seeing the shooter inside the theater itself within 5 feet of him. Dion was shot twice. Louis Duran talking about calling his mother, and of course that was considered hearsay, but he was very emotional and brought it up more than once and had to be cautioned against talking about it. For the first time learning that the gunman, after leaving school, applied for unemployment and cited social issues within school on the unemployment form. Of course, we have those unemployment forms available for you on the denverchannel.com or the 7 News app if you look for the case evidence. Still in May here, May 20th, an EMT, a friend of Jessica Gawi's, describes praying over her body after he'd realized that she suffered a fatal wound. He was in training or had just finished training as an EMT in Texas, an old friend of hers, and attended the theater, the movie with her during a visit here to Colorado. Kevin Quinonez's 27-second 911 call, to me, one of the most emotional and powerful moments of the trial. Just hearing the gunshots in the background, screams, really brought that home, hearing it occur in real time there during that phone call, something that we heard in the preliminary hearing Marshall and I attended, but for the first time made public on May 21st of this year during the trial itself. Then, of course, the much anticipated notebook introduced during the testimony of Sergeant Matt Files, the 30-ish pages of odd rantings and drawings and self-diagnoses and planning of the shooting itself that was mailed to Dr. Fenton at CU. Then the judge issues a ruling dictating how the video from the sanity exam can be viewed. Of course, that did begin a long process of reviewing during Dr. Reed's testimony the 22 hours of video. Of course, Dr. Reed said the gunman knew what he was doing, knew the consequences, and was legally sane. This was the first of 2 doctors to testify to that. As we go through here, there are several days of from the sanity examination itself. Gunman saying, and this is a key moment, "I knew it was legally wrong," is what he told Dr. Reed. Asked how he wanted to be remembered. Of course, afterward, a request for a mistrial, denied yet again. Of course, I should describe, this was in pursuant to the 5th Amendment, the defense saying that because we played video of the gunman incriminating himself, we should have a mistrial. Of course, that was denied. Then, of course, Dr. Metzner, the second doctor, describing his examination of the shooter and the diagnosis he reached. Second doctor, again, I may have a duplicate here. Dr. Metzner saying the gunman was legally sane. Jurors dismissed because of their exposure to news coverage. This was during a period of time for about 2 weeks when we lost 5 of the 24 jurors. Of course, we still have 7 alternates. During testimony, the gunman's selfies were shown to the jury, things that were recovered from a cell phone. We're now in June 11th, when the ex-girlfriend Gargi Dada testified about being the ex-girlfriend of the gunman, things that she had said and traded with him in chat rooms, including a moment where he said that he thought he wanted to kill people. She said she thought he was joking. Here, another juror dismissed after revealing that her brother-in-law was the victim of a shooting in Denver. Dr. Fenton testifying that she never was told about the gunman's developing plan, even though she was seeing him, treating him for 6 times during that period of time at the start of the first half of 2012 when the plan was developing. Of course, she said that she never heard about the plan, never knew that there was a target in mind, and therefore never had the grounds to cause a legal, a 72-hour mental health hold for examination. Another juror released because the judge didn't trust that she was forthcoming about recognizing witnesses. Dr. Feinstein, who saw the gunman along with Dr. Fenton twice during those months where he was still at the CU Anschutz neuroscience program. He gets grilled by both sides about his questions. That was a particularly energetic cross-examination and redirect and recross. And then the prosecution concluding their case with Ashley Mosier explaining what she experienced inside the theater. Mosier, of course, a very emotional way to end their case. She was paralyzed. She lost her 6-year-old daughter, Veronica, one of the 12 who was killed, and her unborn child. The prosecution rested that same day, June the 19th. Again, the defense motioned for acquittal. It was denied. They have done that twice now, and twice they've motioned for mistrial. All of those denied. And their first witness for the defense, Dr. Jonathan Woodcock, came, testified the opposite of what the prosecution's doctors testified that he believes the gunman was severely mentally ill, that he was that way just 4 days after the shooting, and that he believes he was legally insane at the time of the shooting itself. We should point out that Dr. Jonathan Woodcock and Dr. Gurr were both hired by the defense. The prosecution, however, has taken what you might consider the high road approach, because they have only used state-appointed doctors to make their case. And why do I call it the high road approach? Because they've never paid for an opinion. Dr. Woodcock and Dr. Gurr were both paid by the defense in order to get their work and opinions, whereas the prosecution didn't directly pay Dr. Metzner or Dr. Reed. Instead, they were paid by the state mental hospital. Cross-examination of Dr. Woodcock. Of course, this was a very vigorous cross-examination by George Brockler. In fact, throughout this case, he was quite vigorous in his. Dr. Rachel Davis testifies, I got to fix that to a period, about what she saw in the gunman in that November time period after the shooting. Dr. Elizabeth Loudermilk now talking about how she believed the gunman was psychotic during that November time period when they assert the case the gunman's mental health was exacerbated. Testimony about test results. Of course, he was subjected to many, many different IQ tests, MRIs, CAT scans, all kinds of things during his commitments to the Mental Health Institute at Pueblo for the state-ordered sanity exams, of which there were 2, and they both lasted several weeks. And then, of course, the tests that he underwent when he was at Denver Health in November of 2012. Attorneys now questioning Dr. Gurr's credentials. This is July 6th. We have several days here of Dr. Gurr. Dr. Gurr saying the gunman was insane, that his experiences in graduate school were the last straw, that was talking about his vague ideas of wanting to kill many people aloud, pushed it over the end. Dr. Gurr's documentation. This was a key point of contention for George Brockler, whether she wrote down notes during the questioning itself or whether she wrote them down afterward. And she did say that what she wrote in her report was based on notes she recorded afterward in the lobby, not during the meetings with the gunmen themselves. The gunman confirming last week that he would not testify. And then, of course, the defense resting. And that brings us back to today, everyone, where we are waiting now in a prolonged recess for the court to resume as they are finalizing verdict forms and instructions for the jurors. The jury will be, of course, broken up into the 12 voting jurors and the 7 alternates once closing arguments are concluded tomorrow. Of course, the judge knows who those 12 voting jurors are, and the attorneys know who the 12 voting jurors are, but the jury themselves do not know, and we certainly do not know. But it is interesting to think about the prosecution in particular, because Dr. Gurr, she was on the stand for several days and ended up with more than 70 questions about this. And then after hearing those 70 questions, the defense, they decided not to call Dr. Gray, I believe, and the prosecution decided not to call their rebuttal witness, Dr. Resnick. So it would appear that both sides felt that those 70 questions for the star witness of the defense were playing toward their side. So what does that mean? Well, it means that both sides are feeling pretty comfortable with where they are at this point. At least it would appear that way to me, sitting in my seat here several miles up the road. But it appears that both sides felt that those 70 questions for that key witness, that star witness for the defense, the doctor who literally wrote the book on schizophrenia, well, it certainly appears that she answered those questions and was asked questions that both attorneys felt, Dan King and George Brockler felt, played toward their side, played toward their arguments. And it's going to be an interesting dilemma now to see which side gets the verdict in their favor and how these closing arguments go. Well, we certainly do, I suspect, have time to come back and answer more questions, but I think I need a glass of water at this point. So Andrew, let's cue up, if we can, the video. We've played this highlight reel for you before. We're going to play it again, and I think we'll have time to get all the way through it this time. Highlights from the opening statements, things that the attorneys asked the jurors to be listening for throughout the course of this case, throughout the 47 days that followed. We're going to play that for you now and take a minute to catch our breath. On the flip side, please do ask some more questions on the chat room because I think we'll have time to discuss them.
On a cool July night a few years ago, about 13 miles from where we sit right now, 400 people filed into a box-like theater to be entertained. And one person came there to slaughter them.
Aurora 911, where's your emergency? I can't hear you. What address? Theater, Aurora, Colorado. Yeah, but I can't hear you. Give me the address again. There's gunshot. What address? Say it loud.
The man that came there that night, covered head to toe in armor to protect him from any injury. The man who brought with him 4 weapons and hundreds of rounds of ammunition. He's in the courtroom with us today. Now, what I'd like to do is just talk to you about victims in this case. What I'd like to do is to focus us on those who were most affected by this conduct. But here's the thing. He made so many victims that if I were to stand here and merely spend 1 minute per victim telling you about them, about how they got to the theater that night, and about what he did to them, I would be here for almost an hour and a half. I can't do that. But what I can promise you is that before this case is over, you will hear from or about every one of them. Rebecca Wingo. Rebecca is a 32-year-old mother of 2 young girls. She had been in the military, but had hopes of doing something else, becoming a social worker. And on this particular night, she comes to the theater with a friend. Michaela Medic is 24. She's a local girl. Graduated from Gateway High School early, took her GED. She was taking prerequisite classes at college, wasn't sure what she wanted to do yet, but she worked at Subway. And on this particular night, she and her friends decided they wanted to go to this premiere of The Dark Knight Rises. They get there. The only seats that are available to them suck. They're 3 rows off the screen, and they're horrible. But she and another friend out of that group of 5, just as the theater's about to get dark, look back. And they see 2 open seats, about 4 rows from the top, and they take him. He pleaded not guilty by reason of insanity, and there were 2 psychiatrists, about a year apart, asked to do independent assessments and evaluations of him. Jeff Metzner and William Reed. Those psychiatrists, those expert forensic psychiatrists, were not picked by the people of the state of Colorado. They were not picked by the defendant or his attorneys. They were picked by the Colorado Mental Health Institute of Pueblo, the state mental hospital, at the direction of the court. And both of them say the same thing, that guy was sane when he tried to murder all those people in that theater back in July of 2012. They each spent a great deal of time evaluating the defendant. Do something that you want to do that's fun. She knows he's been having a tough time. This is what she says here. He says, well, look, what I really want to do, I can't do because it's evil. She says, well, and he says, I can't do that. Well, what do you feel like doing? Video games are the next best thing. They're escapism. What's so evil that you want to do? And you know what he says? Kill people, of course. She thinks this is just theoretical based on all of these other conversations they have, so she engages him. Killing people's too much effort. You'll end up locked up. Most people aren't worth the effort. He says, well, that's why you kill many people. Again, she thinks it's theoretical, and they continue to have a conversation. He invokes justice, saying taking away someone's time or life. And in fact, if you wait to kill to the end of your life, then there's nothing to lose. They begin to have a conversation about the value of life. And he says, what's more valuable than life? If you take that away, you take away everyone's experiences and all of their potential. And she asks about that, and he talks about it being human capital. And she says, what is human capital? What do you do with that human capital from having taken away people's lives? And he says, have a more meaningful life. And she doesn't get it. How does that work? And he can't explain it to her other than saying, this is what he wants to do. She says, it may satisfy you, but it doesn't fulfill your purpose. He says, but it'll still make my life more meaningful. And she still thinks this is just a theoretical conversation. She says, I don't see how it's useful. She confronts him and says, it's not like by killing people, you get the benefit of anything from them. You're not stronger. You're just taking away life. And that seems like destruction. And he says, look, I don't believe in absolute good or evil. She says, well, if that's the case, why don't you kill me and Ben, their mutual friend, who wronged him, she, by breaking up with him? Why don't you do that? He says, I told you I can't do that. If I did that, I'd get caught, and I couldn't kill more people. I'd also lose the rest of my life. He says that it's a circle, a tautology, saying that the meaning of life is to live. He recognized that long ago. But you know what he's missing? A purpose. A purpose. He says, I'm not inherently evil. My outlook on destroying life is only plan B. I do have a plan for good. And she asks, what's your purpose for good? And he says, are you sure you want to know? You don't just want to find out? And then she says, hey, can we continue talking about this later? Because it's just theory. Ben's coming to pick me up. He responds with, Ait, you want to come play some Dom? That's a board game that they play at his house, that they've all played for a long time now. She says, I got some things to do, but after that we can. And that conversation is left like all the others. By the time he gets into that theater on July the 20th, there is not a millimeter of flesh that isn't covered by some protective armor or piece of clothing. But he also buys some clamps. These clamps that he's going to use for a tablecloth, he manufactures into the device he uses to keep the exit from the theater from locking behind him when he goes out to get dressed in his kill suit with his weapons while the previews are playing. It's like 15 or 20 minutes into the movie. He starts with the shotgun, and he begins to pull the trigger. This shotgun. Boom! A.J. Boyk, who had been sitting with his fiancée is hit and killed as 14 pellets penetrate his brain. Boom! Our Air Force soldier, Jesse Childress, who had come with his friends and purchased their tickets. He too is hit by the shotgun blast, and it rips through his lungs, heart, and organs, and he dies.
When James Holmes stepped into that theater in July of 2012, he was insane. His mind had been overcome by a disease of the brain that had plagued him and pursued him for years. In his words, I have fought for years and years to overcome my biology. But in the end, when florid psychosis erupted in 2012, he lost that struggle. He lost that struggle in his mind to a disease called schizophrenia.
So we just want to make sure that your hands are protected. Yeah. Do you know what this is for?
That's what I'm asking.
Huh?
That's what I'm asking.
What do you think it's for?
Popcorn.
For popcorn?
Yeah.
Could be used for popcorn.
For the first time doing anything wrong in 24 years, steps into this movie theater and commits this unspeakable crime for no reason. The reason is that he has a psychotic delusion that he thinks it will somehow increase his self-worth, his human capital. It's nonsense. But to him, it was so real and so powerful that nothing else mattered.
His thinking was diseased. His thoughts were telling him things that weren't true, and his thoughts were telling him that he was in a life struggle that had no basis in reality, didn't exist in reality, but to him, he believed it with every fiber of his being.
All right, and with that, we conclude our replay there, about 10 or 12 minutes from the opening statements from both sides. So we do still have this recess ongoing in Arapahoe County Court while the defense takes a few minutes to read some of the judge's revisions to these instructions, while the sides are getting ready to conclude this process of finishing the jurors' instructions and finishing the verdict forms, finalizing everything. I know that the judge wanted to get copies of all of that to both sides in their entirety so that both sides can sign off on them and we can move forward to closing arguments scheduled for tomorrow morning. In the meantime, we've talked about, I've asked you for some more questions on our chat rooms here, and so I'm going to ask Andrew to pull up our computer screen for another minute. We'll look at a map here. Again, onto the maps. Arapahoe County Court. Some of you were asking about how the families and jurors and things get in or out of the court, and so I wanted to take a moment to show you all of this. Arapahoe County Court here, and I'll zoom out for a second to show you some perspective of where it is in relation to, say, downtown Denver, which is up here in this corner. Of course, I'm on, there we go. Downtown Denver is here. Our TV station is in this area right underneath the little pop-up box. Aurora 225, Buckley Air Force Base, giving you a couple of the Denver Tech Center, a couple of the landmarks in case any of you have ever been through the area or if you live here in the area. So it's good to say south of Cherry Creek Reservoir, south here near Dove Valley, which is the Broncos facility. It's actually just next door to the Broncos facility. You can see their practice fields right here. But let's zoom back in for a second and talk about this courthouse itself. So Arapahoe County, this building here is the jail, the detention center. Underground, there is a tunnel through which the gunman and other defendants can be brought into the courthouse. This is an updated photo because you can see the breezeway here between the two different buildings. We've got building A and B, I believe they're labeled, or 1 and 2. Here, this side is where attorneys and jurors all park, families, victims, survivors, etc. park on this lot. The media, the public park down here, and in fact the media has been blocked out to, gosh, I wish I could draw a box around it here, but this area, about 2 or 3 rows here. And I can tell you that today this area is absolutely bustling as media outlets from all over the country and the world get ready for tomorrow. What we've done, the way the signal gets out of here, is there is a setup, a transmitter on the roof here. It sends to a machine over here that receives it and then brings it down the wire and disseminates it out to all of the trucks and trailers and things that media has parked here in the corner. And that is the general layout of the court. Of course, there's also an overflow parking lot that's going to be opened. It's somewhere down along here. I believe it's here. Overflow parking lots available in case the crowd is too large for tomorrow. Certainly it may well be. If you don't mind, Andrew, we can come back on screen for a second. I can read something aloud, and I'm sorry I don't have it up on the screen of the computer that's tied into our switchboard. But last week, the judge did issue a media alert, and some of you in the past have asked this question, so I'll take a moment to explain how this process works. There are, let's see, there are 40 seats allocated to the news media in the courtroom itself, where the proceeding is actually occurring, and then there are overflow seats outside of that. All of the reporters involved have already reserved their seats, so those seats are unavailable. However, if any seats are not picked up, or if anyone is not in their seats by 8:30, there's going to be a first come, first serve opportunity, which theoretically is open to absolutely anyone. Of course, beyond those 40 seats, they're reserving seats for the families and survivors in the courtroom 201 itself. They're also going to have courtroom 202 in overflow seating. Now, I would just want to point out, while these are potentially available to the public, if there's enough room and space after the demand for survivors and media, while any of you could potentially show up tomorrow, if you get assigned to courtroom 202, you're going to end up watching the same kind of camera feed that we get and transmit to you from here. Because 202 and 201, there is a solid wall between them. They'll have a projection screen out there for that. So the closed circuit camera is what's going to be available in 201. Outside of the building itself, there are designated areas where we are allowed to stand with cameras. If anyone shows up from the public with cameras, they would also be, and they leave those designated areas outside on the grass by the parking lot. They would be in violation of the media rulings that have been in place since January, since the start of the jury selection process, and very easily could have themselves banned from the courthouse or found in contempt of court. The last thing that's on this document that the court sent out is there will be a room for a sketch artist. So in addition to the perspective we'll have from our camera that we've been looking through since April now, since the 27th of April, there will be an opportunity for a sketch artist at the ground level to give us a different view of the courtroom. So now let's take a moment and look through, since I did ask for a couple of other questions, not just about the courthouse. Are we going to play closings on TVs like we did for the openings? And unfortunately, due to the scheduling at this time, we are not able to do closings on television. We will have highlights and cut-ins and things like that available on television throughout the day. We'll have a ticker on the screen with updates whenever it's possible. But the only place that we're able to carry closings in their entirety will be on your computer on thedenverchannel.com, on the 7 News app. And what I can do is I can promise you this, after the hearing today concludes, I'm going to establish the link for tomorrow. Even though the video feed won't be started, I'm going to have it ready and rolling so that anyone can bookmark it, get ready to watch it for tomorrow. It's the same process we'll do for closings as well for the verdict as well. Once the closing is done, we'll establish that stream link so that it's available and waiting for you. And all you'll have to do when you get that push alert, when you get that email alert from us that the verdict is in, you'll just have to click on it and there you go. Can you see the not guilty by reason of insanity numbers? And NT8, I'm not sure exactly what you mean by your question there. So if you want to send it again, I'm not sure, sir, what you mean by that. Let's see if there's any other questions on YouTube, and then we'll give that a chance. Forgive me as I just scan through for a second. Has either side shared what evidence exhibits they'll be using on close? And that's an interesting question. I have not seen that in any written documents that have been made public. Now, if they are, if they've shared that amongst themselves, I have not seen it. Certainly, they can't go outside the evidence that's been presented in the trial so far, and we don't know yet what they'll do. But remember, they only have 2 hours, and remember that the prosecution is only going to use about 90 minutes or so of their time during their first opportunity, and then they'll save about a half hour for the rebuttals. That's how George Brockler has expressed his plan for the time. They won't have a lot of opportunity to show very much evidence. The one thing that they could do is they could create slides. I know that was discussed at least in part last week. They could create slides, a slideshow, a PowerPoint presentation or a keynote presentation to show on the screens as they go through their closing argument. Well, with that, folks, I think it seems like I've covered the questions that I can see on my little scroll through here. So we have some time, obviously, still remaining. The court has not resumed. It is 10:45 Mountain Time. At this point, we're going to replay, because it is so important to keep this in perspective. We're going to replay some of the survivors' montage that we have assembled throughout the course of this trial. We have many hours of it, and we're going to pick a spot and just play some of that for you, since it is obviously about seeking justice for them in one way or the other. And we'll hit that, and once we see the court resuming to continue with these hearings today, we'll interrupt and bring you back to the courtroom live.
Just inside the door when I walked in. I bent down, felt for a pulse. There was no pulse. The only wound I could see was a wound in the abdomen on the right-hand side. At that point, I saw Sergeant Hawkins, who was an officer at the time, coming down the stairs. I got his attention and said, I want her triaged, I want her out of here. He picked her up and carried her out. He felt for a pulse. Later had mentioned that he thought he felt one, but he hadn't because his own pulse or something to that line. But
even though, when you first saw her, did you feel that she was still alive?
No.
Given that, why did you choose to not leave her in the theater?
Her age. I wasn't keeping a child in my crime scene. You know, if there was any possibility she needed to go. I didn't want my officers stepping over her. I didn't want her at the scene.
My next recollection is Sergeant John Scard motioned me over, and there was a girl about 6 years old on the floor.
Did he ask?
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that the defendant is present with the same attorneys and the same prosecutors are present. Before we get to Ms. Nelson, let me make a record about a couple of other things with respect to the instructions. In terms of all the instructions that mention the term universal malice, my understanding, Ms. Nelson, is that you don't want me to give a definition of universal malice. And as you know, universal malice is not defined by statute, but the case law contains a few different definitions or comments. The one that comes up most often is that universal malice is defined as that depravity of the human heart which determines to take life upon slight or insufficient provocation, without knowing or caring who may be the victim. That's from People versus Jefferson, 748 Pacific 2nd, 1223, Colorado Supreme Court, 1988. And originally it was from Longinati versus People, Longinotti, 46, Colorado 173, 102, Pacific 165. That's a case from the Colorado Supreme Court from 1909. And People versus Ellis, it's a Colorado Court of Appeals case that also has that definition. That's cited at 30 Pacific 3rd, 774, Colorado Court of Appeals, 2001. But I think that the definition originated in Longinati, and in other cases I've quoted it since. In People versus Rodriguez, 888 Pacific 2nd, 278, Colorado Court of Appeals from 1994, the court stated that the element of universal malice required for extreme indifference murder has been defined as aggravated or extremely reckless conduct. And the court cited to People versus Jefferson for that proposition. And then finally, in Longinati, the court also said that universal malice is evinced by acts which are calculated to put the lives of many persons in jeopardy without being aimed at anyone in particular. My understanding of the conferences that we've had on jury instructions is that the defense is asking the court not to give any of those instructions. Is that correct?
Yes, Your Honor.
Okay. And the people are not seeking that any definition be given on universal malice?
I don't think it's necessary, Your Honor.
Okay. I came up with a list of admonishments for the alternates. I'm going to deviate from the instructions for just a moment because I don't want to forget to do this. And I came up with 10 admonishments. And what I'm intending to do is have them blown up and have them in the room where the alternates are going to be. So I'm going to have my staff make you a couple of copies of these, of the admonishments so that you can see them. But for the record, they read as follows. Number one, please do not discuss any aspect of the case with each other through any means. You are free to talk to each other. There's a typo there, and I'll fix that. You are free to talk to each other, but not about the case. You are not allowed to deliberate in any way or discuss any aspect of the case. Number two, in addition to not being able to discuss any aspect of the case with each other, you may not communicate about the case with anyone else through any means. All you can tell people is that you're a juror in a trial in Arapahoe County that is expected to end at the latest in August. Number three, you may not have any contact or communications with any jurors who have been dismissed or with any jurors who are deliberating. Number four, please do not talk with any witnesses, parties, or attorneys about anything, whether related to the case or not. Number five, to make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you are on the courthouse premises and that it is visible to everyone around you. Your juror badge will also reduce the risk that people will talk about the case in your presence. If you hear anyone talking about the case, please remove yourself from that location. In the event that, despite your best efforts, you hear something about the case, please let my staff know that you want to talk to me. Number six, please do not talk to any members of the media about anything until these proceedings are completed. Number seven, you must not read, view, or listen to any news or media reports that may refer to this case. Because there's media coverage of this trial, please be particularly vigilant while listening to the radio, watching TV, reading the newspaper, and using the internet or any electronic device. Number 8, you cannot visit any locations mentioned in the case, nor are you allowed to conduct your own investigation outside the courtroom. This includes consulting outside references in relation to this case or a case like it. Number 9, all decisions in this trial must be based solely on the evidence presented in the courtroom and the instructions of law that I provide. And number 10, you cannot form any opinions about the case or deliberate internally, and then in parentheses it says privately, about the case. You must resist any temptation to deliberate. I'll give you a copy with that correction, but generally, any objection from the people to having that in the room where the alternates are going to be held?
No, Your Honor.
Any objection from the defense?
No, Your
All right, great.
Not as far as we could follow along anyway.
Okay, thank you. Before I forget, I wanted to make a record about the fact that we had an initial jury instructions conference on June 24, and then we had another one on July 2nd, and then we're having this one today, July 13. And I want to incorporate by reference the record I made on July 2nd as well. We did not have a conference on July 2nd, but I gave the parties a draft of my instructions. That's the draft of the instructions that we worked on last Friday on July 10. And I made some comments on July 2nd. It was toward the end of the day on July 2nd, related to People versus Bielecki, Bielecki, 964 Pacific 2nd, 598, Colorado Court of Appeals case from 1998. People versus Collins, 752 Pacific 2nd, 93, Colorado Supreme Court case from 1988, and Colorado Revised Statute Section 16-8-105.5, subsection 3. And based on, or I should say that the comments I made were to reflect that I had changed the initial draft of the instructions that I had distributed to the parties. And the reason for at least some of those changes had to do with the authority that I just cited. And I explained that on July 2nd, neither side responded, although I could see that both sides were seemed to be a little surprised by my comments. I allowed the parties to review that draft of the instructions, and then we returned last Friday to discuss the instructions further. That was on July 10. And then we worked on July 10 on the instructions, or the draft of the instructions that I distributed on July 2nd. And then based on the conference that we had on July 10, last Friday, I created a new draft, and that's the draft that I distributed today. So I wanted to incorporate by reference the record I made on July 2nd. I also wanted to make a record with respect to a couple of comments that I made. I think it was on July 10, and it may have been on June 24 as well, but I'm pretty sure last Friday I said that just because something is in the case law, or just because there is law on something, doesn't mean that I should instruct the jury on it. And I said there's case law on this in Colorado, and I found that case law over the weekend, and so I wanted to incorporate it into the record now. It's People versus Lane, Lane, 343 Pacific 3rd, 1019. That's a Colorado Court of Appeals case from 2014. And here's what Judge Gabriel said in that opinion. And Judge Gabriel, as you know, has just been appointed by the governor to be the new justice on the Supreme Court. As our Supreme Court has made clear, a trial court's use of an excerpt from a judicial opinion in a jury instruction is generally an unwise practice because opinions and instructions serve very different purposes. The court then cited to Evans versus People, 706 Pacific 2nd, 795, Colorado Supreme Court case from 1985. The court in Lane went on to say, in Cohen versus People, that's Cohen, 106 Colorado 245, 103 Pacific 2nd 479, Colorado Supreme Court case from 1940, the court explained that statements taken from opinions do not necessarily translate with clarity into jury instructions because opinions and instructions have very different purposes. Language used in an opinion pertinent to the issues and the determined facts in that case may be a proper expression of the law as related to those facts and issues and pertinent to a decision of the case, and yet may not be sufficiently general, clear, or accurate to serve as a satisfactory or full instruction to a jury. So I wanted to supplement the record with respect to that. One more supplementation of the record, and for this one, I'm gonna need the one attorney to approach. I just wanna make sure we're all on the same page in terms of who we think is a deliberating juror and who we think is an alternate juror. So would somebody please approach with your list of alternates or unless you haven't memorized? Or can I give it to you now and then check and then tell me tomorrow if I misstated? Is that all right?
Yeah, I have a pretty good memory, but.
All right, do you wanna why don't you approach it so I can give you my, what I show, and then you folks can tell me later if you disagree. Just one last thing, just as a follow-up, because I don't want to forget, Mr. Orman, you had indicated that you were going to follow up on the penalty phase instructions that you submitted to see whether they had been the type that have been reviewed by the Supreme Court and had in the past. And I know we just had the conversation on Friday, and you may not have had an opportunity to do that. I'm not asking you about it now. I'm just saying if at some point you find out additional information, then I would like to know that, okay?
Thank you.
All right, thank you. All right, let's get to the instructions then. Ms. Nelson, have you had an opportunity now to review the latest draft of the instructions and the verdict forms? And for the record, we will post them so that, not post them, but we will put them in the court file so that the record is clear as to what the draft of the instructions that we've been talking about today looks like. So, Ms. Nelson, where would you like to start?
I think it might make sense to start with the informational instruction about the consequences of a not guilty by reason of insanity
Okay, let me get there.
verdict.
Okay, go ahead.
We continue to maintain our position that the instruction on this issue that we submitted should be given, but without waiving that position. We do prefer this new version over the previous draft version that the court had circulated. I would ask the court to consider changing the court's duty to commit him to this court's duty to commit him, since it will clearly be this court and not just a court. And that goes along with what the court was saying earlier about changing and personalizing a little bit to the defendant. I think it's appropriate to say that it will be this court that commits him to the custody of the Department of Human Services.
I agree with you. Is there any objection?
Much better the way it's written right now, Your Honor. I think it's very clear.
Well, I mean, it is sort of semantics. I mean, it is the court is this court, so.
It's not necessarily you, Your Honor. I mean, you could go on to other duties in the future, other courts. And I think that when you say this court, that is saying it's going to be you.
But this is talking about the duty to commit him, not with respect to whether he's eligible for release. So this is if the defendant is found not guilty by reason of insanity, it will be this court's duty to commit him to the custody of the Colorado Department of Human Services until such time as the court determines that he's eligible for release. I don't think we need to change both, but the way I understood Ms. Nelson, she's asking to change the first one where it says it will be the court's duty. Right, Ms. Nelson?
Yes, well, I should say that at the previous charging conference when we discussed this instruction, we had asked the court to change both, but I understood the court to have already rejected that request, and so my new request would just be to change the first reference to the court to this court.
Mr. Orman?
Certainly, Your Honor would be the one doing that, but I think that by changing it, you imply that it would definitely be Your Honor doing the latter, and obviously, that may be the case. It may not be the case. So I just think it makes it much more confusing.
And I disagree, Your Honor. I just think that it makes it clear that it's this. It doesn't say that you personally would be doing it. It says this court, which is the Arapahoe County District Court. And certainly it will be you committing him to the custody of the Department of Human Services if there is a not guilty by reason of insanity verdict. And then I think it's appropriate, given the court's ruling at the earlier charging conference, to just keep the second reference to the court as the court.
I'll change the court to this court. I don't think there's anything I don't think that makes it more confusing in any way, and I think it's accurate. So it'll say, if the defendant is found not guilty by reason of insanity, it will be this court's duty to commit him to the custody of the Colorado Department of Human Services until such time as the court determines that he's eligible for release. Frankly, this court doesn't necessarily refer to me anyway. It's this court. I am the judge assigned to this court, but I think saying this court will have a duty to commit him is appropriate, and I think that's accurate. So, okay, what else?
And then we would just we would ask the court to consider adding the paragraphs that we had proposed in our initial instruction about the burden of proof being on the defendant to establish that test, as well as adding the language that we proposed in our original instruction, conveying that the court can impose such terms and conditions. If the court finds the defendant eligible for release, the court can impose such terms and conditions as the court determines are in the best interest of the defendant and the community, which just makes it clear that it's not just, the defendant just being sent on his way without any additional court supervision.
Your Honor, I think we had a long discussion about this the last time, and there were many aspects of the defendant's proposed language that we believe were actually factually inaccurate. This language is accurate, it is easy to understand, and as Your Honor indicated earlier, these should be brief and easy to understand, and not the way a law school lecture would undertake to present this topic. And the court's instruction is a much better instruction.
I agree, and there are all kinds of details in the statute, and I mean, you get into a slippery slope. How far do you go? How many details do you give the jury? And if you only give some details, do you run the risk of giving an incomplete instruction or a confusing instruction or an instruction that misleads the jury? If you get into the burden of proof, then at that point, why don't we get into a hearing, and when the defendant is entitled to a hearing, and how the court in some situations has to have a hearing, and what the procedures at the hearing would be, and what type of evidence the court would have to consider at the hearing. I mean, if you get going into one of these details, then I think to be fair and complete, you have to include other details. And then if you include those other details, you have to include additional details. And pretty soon you're giving the jury a mini law school course on eligibility for release. And by the way, this is not an uncomplicated topic. If you go through all those details, there are procedural requirements, there are substantive issues, there are all kinds of concerns and considerations involved. And I don't think what Thompson had in mind was to give the jury all the information available on the subject matter. What Thompson had in mind was to make sure that there was not a miscarriage of justice as a result of the jury assuming that a not guilty by reason of insanity verdict would be the same thing as a defendant walking out of the courtroom just as if he was found not guilty. So the request is denied. And I incorporate by reference any other comments that I've made in previous jury instructions conferences on this issue. Anything else, Ms. Nelson, with respect to that one?
No, Your Honor. Is the court referring, is it Thomas, People versus Thomas, or Thompson?
I think it's Thomson. Thompson.
Thompson. Okay, I'm sorry.
Yeah, I think that's the name of the case.
Yeah,
Thompson.
no, that's it for that one.
Okay.
And then next, if we could discuss the theory of defense instruction.
Okay, let me get there. Got it.
We would ask the court to consider, we have a few proposed revisions and changes, but without waiving our request to submit our initial original instruction.
I just want to make sure we have a record of this. Is the court going to make this packet of instructions some type of court exhibit so that we make sure that we have a copy of the one that the court drafted in the record in case it needs to be referred to by another court later on?
Yes, as I said, I will file this draft. But just to be safe, just to be on the safe side, and I intended to do this, and I should do it now. Let me read it into the record, just to be clear. Here's how I redrafted the defense's tender theory of defense instruction. It reads as follows. It is the defendant's theory of defense that he was insane at the time of the commission of the acts. The defendant asserts that he suffers from a chronic and serious mental illness with psychotic features, which falls within the schizophrenia spectrum of disorders. The defendant further contends that in the spring of 2012, his mental illness worsened. The defendant claims that around that time he experienced his first psychotic break and began to suffer from a psychotic delusion that he could increase his self-worth by gaining human capital and killing people. And human capital in that sentence, by the way, is in quotation marks, because that's how it appeared in the defense's tendered instruction. The defendant, and it's like that every time that term comes up, and again, that's consistent with the tendered instruction. The defendant acknowledges that he engaged in planning and preparation, but avers that he did so as a result of a delusional belief and psychotic thought process with the purpose of pursuing a psychotic delusion that he could increase his self-worth and human capital by killing other people. The defendant maintains that his delusional belief system was born of his mental illness, obscure his ability to make moral distinctions, render him incapable of understanding that his actions were wrong from a societal perspective of morality, and interfere with his ability to act with reflection and judgment concerning the charged offenses. Ms. Nelson.
And Your Honor, just to make sure that I made a clear record about this on Friday, our request would be that instead of the defendant, the court refer to our client as Mr. Holmes.
You did, and I denied the request to be consistent throughout because I used the defendant throughout the instructions. And so I think it makes sense to be consistent. What else?
We would request that instead of, in the second sentence, instead of having the defendant asserts, the defendant states. And that we would also request the same change for the next two sentences. So instead of the defendant further contends, the defendant further states. And instead of the defendant claims, the defendant states.
What's the people's position with respect to those three requested changes?
Object, Your Honor. That almost implies that the defendant himself is saying this. The defendant states. That's, I think, the implication of that particular verb. I think that the way the court has drafted it is much more correct and accurate.
I agree with Mr. Orman. I mean, these are assertions by the defendant. It's the theory of defense. I don't know whether the jury may infer something incorrect or wrong from states. He did not take the witness stand and did not testify, and saying state almost seems like a substitute to that. So I'm happy to change contends and claims to asserts if you like that better, or I'm happy to use a different term. And frankly, I will change asserts if you don't like that either. But it has to be, I think, accurate in terms of this is what he's arguing, this is what he's asserting. So, Ms. Nelson?
I think our preference then in that case would be to change everything to asserts.
Asserts? Okay, I will do that. So then it will say in the third sentence, it will read, the defendant further asserts, and then in the next one, it will read the defendant asserts instead of claims.
Yes.
Okay, great. All right.
Can I make a similar change for avers in the next paragraph?
Well, I don't know. We haven't gotten there yet. Do you have any, with respect to the next paragraph, are you requesting that I do the same thing with respect to avers?
I do, but I also have a additional requested change to that sentence, so maybe let's stick to the first paragraph, and when we get there, I can explain what it is.
Sorry. Yes, I think that makes sense.
So we would also ask the court to consider adding a sentence after the second sentence. So it would read as follows. I'll read the second sentence first, and then I'll read the proposed additional sentence and explain why we think it's necessary for the court to add it. The defendant asserts that he suffers from a chronic and serious mental illness with psychotic features, which falls within the schizophrenia spectrum of disorders. Then we would request that the court add the following sentence. The defendant asserts that he exhibited subtle signs and symptoms of an emerging mental illness for years leading up to the tragic events of July 20th, 2012. And the reason that we think it's important to include a sentence regarding our theory of how this mental illness developed for Mr. Holmes is because there's a dispute between the parties. The prosecution seems to be arguing that Mr. Holmes was born with these fixed personality traits that later caused him to commit these acts, or it played a role in what happened. And our position is that he suffers from a mental illness, and that these subtle signs of mental illness that have been discussed by the experts emerged over the course of a number of years. And so that's why it's important to us to have a sentence in the theory of the case instruction reflecting that difference in position.
All right, Mr. Orman?
Not supposed to be a substitute for closing argument, and the defendant can certainly argue that, but I believe that the sentence proposed by counsel is argumentative, and words like subtle and so forth I think are grossly improper for a theory of the defense instruction, and I don't think that's necessary. Again, they are going to get 2 hours to do a closing argument. The purpose of this instruction is not to take that closing argument back into the jury room with the jurors in written form.
And frankly, as I drafted this, I felt I was being fairly generous and allowing more, erring on the side of allowing more as opposed to less. But and I thought about the sentence that Ms. Nelson just mentioned. I think that sentence is more argument than theory of defense, and I think it's more appropriate for closing argument than adding it to the instruction. Furthermore, the sentence that follows, I think, takes care of it, because it says the defendant further asserts that in the spring of 2012, his mental illness worsened. The only reasonable inference to be drawn from that is that the defendant already had a mental illness prior to the spring of 2012, and that mental illness worsened, that it became worse in the spring of 2012. So I think it makes the point, and it does it in an appropriate fashion. It's not argumentative, and you get the idea out there. So I don't think, I think once you get into the details, such as were these subtle signs and symptoms of something, or was it something else? Was it a mental illness? Was it something else? When you get into terms like subtle, emerging, it just, to me, seems argument. That seems more like argument than the kind of thing that belongs in a theory of defense instruction. So that request is denied. What's next?
Then at the beginning of the second paragraph, we would ask the court to consider adding a sentence, the defendant asserts that planning and preparation is not inconsistent with mental illness, psychosis, or sanity. That's somewhat of a restatement of one of the original sentences that we had submitted with our theory of the case instruction, but adding the defendant asserts language to the beginning of that sentence to put the rest of the sentence into context. The rest of the paragraph into context.
Mr. Orman.
I think the proper verb for that sentence would not be asserts, it would be argues, because that sentence is completely argumentative, and we would object to it.
That's why I didn't put it in there. I think it is improper. I think it is argument, and furthermore, the point is made in the second paragraph anyway. That's what the second paragraph is about, and especially the first sentence in the second paragraph says, the defendant acknowledges that he engaged in planning and preparation, but avers that he did so as a result of a delusional belief and psychotic thought process with the purpose of pursuing a psychotic delusion that he could increase his self-worth and human capital by killing other people. The statement that Ms. Nelson is asking me to add is a general statement about whether planning and preparation means something or doesn't mean something, or whether it's consistent with something or not, or inconsistent with mental illness specifically. And I think that's argument. That's a general statement. That's not even a statement that is specific to this case. That's a general assertion, a general argument that I know that parties disagree on. And I think that's, again, more appropriate for closing argument than a theory of defense instruction. And furthermore, as I said, it would be cumulative and repetitive, just as the last request to add would have been cumulative and repetitive. So that request is denied. What's next?
So then with the first paragraph of the first sentence of the second paragraph, we would request that the court rephrase it in a few respects. We would ask that the court change avers to asserts.
Okay, that request is granted.
And then next, we would ask that instead of stating as a result of a delusional belief, the court change it to read as a result of his delusional beliefs, plural, which is consistent with our theory of defense of the case. It's not just a singular delusional belief. There were multiple delusional beliefs that were referenced by experts and described as it's a belief system. And that was the way that we phrased it in our original proposed instruction.
Okay, you're right. That is how it's phrased in the original. All right, Mr. Orman, any objection? I have changed avers to asserts because that's consistent with my previous rulings, changing contents to asserts and claims to asserts in the first paragraph. What about changing as a result of a delusional belief to as a result of his delusional beliefs?
My preference would just be to take out the letter A and make beliefs plural, so it would read a result of delusional beliefs. I think using the word his under those circumstances makes it some sort of the sort of type of factual assertion that the cases have talked about being inappropriate. It's almost the court saying he had delusional beliefs. I think that, I don't object to making it a plural term, but I object to the word his.
Well, but I think saying of delusional beliefs implies the same thing. I mean, it's the same thing. Again, this is semantics now. And if I say, but he asserts that he did so as a result of delusional beliefs, well, obviously, this would be delusional beliefs that apply to him, and that's why he did this. That's what he's asserting. And I think it's clear that this isn't coming from the court. This is coming from him. This is what he asserts. So I'll grant the request. What's next?
And then also with respect to that sentence, we would ask that the court change the last part of the sentence that begins with the purpose of pursuing a psychotic delusion, etc. We would ask that the court change it to, and that his purpose for engaging in planning and preparation was to pursue a psychotic delusion that he could increase his self-worth and human capital by killing other people. So the entire sentence then would read as follows. The defendant acknowledges that he engaged in planning and preparation, but states that he did so as a result of his delusional beliefs and psychotic thought process, and that his purpose for engaging in planning and preparation was to pursue a psychotic delusion that he could increase his self-worth and human capital by killing other people. Does that make sense?
Yeah, I think you said states, but I've used asserts.
I'm sorry, yes, asserts.
Right.
That was our original request, was states, but
right.
Asserts.
Mr. Orman?
I don't have a problem with that, although I did notice something as counsel was reading that. I wonder if by changing delusional beliefs to plural, we've introduced, a grammatical anomaly, because it was a singular belief and psychotic thought process. And making that plural, I wonder if we either need to add the letter A before psychotic thought process or change that to processes. I'm not sure exactly what the assertion is, but I think that the way it's going to be written now, it reads wrong somehow.
Ms. Nelson?
I'm sorry, so the request would be to change...
You see where in the second line in the first sentence, the second line of the first sentence, it says now his delusional beliefs. Mr. Orman is saying that maybe we need to add an A psychotic thought process there, the letter A before psychotic thought process, or change psychotic thought process to psychotic thought processes. And I tend to agree with that suggestion.
We don't have a problem making process plural.
Okay, I'll make it processes, and then I'll make the other change. I think the other change is fine. So, give me just a second. So now that sentence reads as follows. The defendant acknowledges that he engaged in planning and preparation, but asserts that he did so as a result of his delusional beliefs and psychotic thought processes, and that his purpose for engaging in planning and preparation was to pursue a psychotic delusion that he could increase his self-worth and human capital by killing other people.
Yes.
All right, what else?
Next, we would ask that the next sentence be made into a new paragraph. The previous sentence talks about planning and preparation, and then the following sentence talks about our theory for why he's insane. And so we thought it would make sense to separate that out and just make it a new paragraph.
So where it says the defendant maintains?
Yes.
Okay, Mr. Orman, any objection? Yeah, that's fine. What else?
And then with respect to that sentence, we would like to break it up into two sentences. So it would read as follows. The defendant maintains that his delusional belief system was born of his mental illness, comma, obscured his ability to make moral distinctions, comma, and rendered him incapable of understanding that his actions were wrong from a societal perspective of morality, period. The defendant further asserts that his delusional beliefs interfered with his ability to act with reflection and judgment concerning the charged offenses.
Mr. Orman?
Well, I don't mind that change, Your Honor. However, looking at this, I wonder if it's proper to say that it interfered with his ability to act with reflection and judgment, because the standard before the jury is, did it render him incapable of acting in that fashion? So it's almost an assertion, well, it's not quite rendering him incapable, but that's something that the jury should consider. It's not. They should not be able to argue an improper standard.
Not true, Your Honor, because the court is instructing the jury on lesser included offenses. And if the court recalls, that was my argument as to why we were entitled to lesser included offenses. And the jury can't be restricted to only evaluating whether or not Mr. Holmes was completely incapable of forming the culpable mental state. The due process clause requires that the jury also be able to evaluate whether his whether his mental illness interfered with his ability to form that culpable mental state such that he would be guilty of a lesser included offense.
That's fine. Yeah, Mr. Orman.
That's wrong, Your Honor. I understand that the defendant does not like the fact that the legislature incorporated what used to be impaired mental condition into insanity and would wish it was not so, but they did, and that's the test. And I think what the jury can do and what the lesser included offense would acknowledge is they could say, well, okay, you know what? We would be insane for purposes of the culpable mental state for, let's say, after deliberation. So let's go on to the lesser, because that's a different culpable mental state that wouldn't be interfered with. But they can't just say, okay, it can be some touchy-feely, loosey-goosey means of diminishing his mental capacity in a fashion that is not in touch with the insanity statute. This is an attempt to go back to what we used to have before the legislature changed the statute, and that's why I say it's improper.
Well, I understand Mr. Orman's point. I do, and I think he has accurately stated the law. But this is not an instruction on the law. This is an instruction on what his theory of defense is, and he's not saying this is the standard. He wants to say that this is one of the things he's asserting in general, that people can get up in closing and explain, hey, look at what the standard is. Here's the law, and the law says that this is how you determine sanity. And then you can discuss the theory of defense instruction in that context. You can discuss the evidence in that context. Obviously, this does not substitute what I'm giving the jury as the law, and it would be improper for anyone to get up and argue that this is a substitute for the legal standard, or that as long as the jury is convinced of this last assertion, then they can find him insane. That would be improper. The jury has to follow the law that I give them. But I think in terms of what the defendant can assert in a theory of defense instruction, I don't think it's improper. So I'll make the last change. All right. Anything else with respect to this instruction, Ms. Nelson?
Then we would ask the court to consider including as the last sentence. I assume the court took some issue with the way that we had phrased the last sentence of our proposed theory of the case instruction, which was our original proposed language was, but for Mr. Holmes' mental illness, the tragic events of July 20th, 2012 would never have occurred. And assuming that the court rejected that for a reason, we would ask that the court just include a final sentence. The defendant asserts that his mental illness caused him to commit the July 20th, 2012 shootings, or something to that effect. Again, as I said on Friday, this is absolutely a critical issue in this case. All of the psychiatrists who examined him gave testimony about the role that the mental illness played in the shootings, and for that reason, we think that's an important concept to include.
I did have some issues with that last sentence. I wasn't, the reference to tragic events, you can mention that in closing argument. I just don't think it's appropriate for a theory of defense instruction, but also the but for language. There has been testimony by at least a couple of experts about this, but there is a difference of opinion between the parties as to what exactly that means or what relevance that has. Dr. Metzner said this in his report, that but for Mr. Holmes' mental illness, the shooting would not have occurred, or something along those lines. Dr. Reed then said, well, duh, of course, and basically he took that to mean nothing. That's the way I read his report, and he said...
His testimony was different.
He, I think, was saying that but for Mr. Holmes moving to Colorado, this wouldn't have happened either. But for Mr. Holmes signing up for school, this wouldn't have happened either. But for a lot of things, this wouldn't have happened either. So I understood his testimony to be to minimize that, or to give that no significance or little significance. So I think this is more appropriate for closing argument. Now, in terms of whether you can say that mental illness is responsible, or was responsible, the defendant's mental illness is responsible for the crimes charged in this case, or something along those lines, that's different to me. So let me ask the people to respond to that. Mr. Orman, what's your response to the request for that last line?
It implies to the jury, Your Honor, that they are going to consider that question as a substitute for insanity, and it would be an instruction given to them by the court. There is no but-for test in the insanity statute in Colorado. The tests, I don't need to repeat them, we all know what they are. Those are the tests that the jury needs to consider, not this but-for Paul's graph sort of proximate cause thing. That's just not that's not the standard, and it's an improper assertion in variance with the law under the guise of a theory of defense instruction, so I object to it.
And again, Your Honor, it's clearly relevant. All of the experts testified to it. They didn't object to the question or the answers elicited from the experts. And so we would ask the court to include a sentence stating that his mental illness caused him to commit these charged offenses, or the July 20th, 2012 shootings. It's an integral part of our theory of the case. And I would just add that I make all of the objections and requested revisions, as well as our original theory of defense instruction that was proposed, pursuant to our right to present a defense, to due process, and to heighten reliability required in this capital case, pursuant to the 5th, 6th, 8th, and 14th Amendments to the the United States Constitution, as well as Article 2, Sections 16, 20, 23, and 25 of the Colorado Constitution. And Ms. Higgs just pointed out to me as well that insanity does require, the insanity statute, Colorado's insanity statute does require mental illness, which is prong 1 of the test, as the cause for prong 2. So it's also relevant to the insanity determination for that reason. May I add something, Your Honor? Just to make it clear. Okay.
Okay, Ms. Nelson?
I just meant to say, in other words, the statute requires, and the court incorporated this language over our objection, but it says care should not be taken to confuse mental disease or defect with something else. And so that, because of that language, I think it's clear that it's the mental illness that has to have caused the insanity or the inability to distinguish between right and wrong.
About something along the lines of the defendant asserts that his mental illness rose to the level of insanity on July 20, 2012, and that he is therefore not responsible for the crimes charged.
I don't think that gets at quite the same thing that we're trying to convey, so we would respectfully decline that proposal.
Well, I do worry about this confusing the jury or misleading the jury, because that the causation is not the question. The question is, did he suffer from a mental illness that was so severe that it then rendered him insane, that it rendered him incapable of distinguishing right from wrong, or incapable of forming a required culpable mental state? So it isn't that, mental illness caused, whether mental illness caused a crime or not. Mental illness may have been a cause of the crime, but that doesn't mean that he's insane. That's the part that I'm struggling with. I think that would be an incorrect statement of the law, and I don't want the jury to be misled. And I see this as different in the last sentence we talked about. The last sentence, I think it's a fair sentence in terms of what position the defense can take. I think the defense can argue, hey, his mental illness interfere, or his delusional beliefs interfere with his ability to act with reflection and judgment, because reflection and judgment are related to deliberation, and that's one of the mental states, the culpable mental states that's required here. But to argue that, well, but for the mental illness, or the mental illness caused the crimes, that's not the question before the jury. The question is, was there a mental illness? And if so, was it so severe that it rose to the level of insanity, such that he should not be held responsible under the law? So, Ms. Nelson, if you want, I will add the sentence that I just suggested or something along those lines, but I'm concerned about a proximate cause type of concept and adding that to the theory of defense instruction, because I think it's a misstatement of the law. If you want to argue it in closing argument, I think it's appropriate, but I don't think it belongs in the theory of defense instruction. Frankly, I think as it is, this theory of defense instruction, even without that language and without the suggested sentence that I just uttered, is complete, and it is appropriate, and it is fair. And as I said, I'm being generous. And frankly, I would have been justified in shortening this quite a bit. And I would have been justified in saying this is a 2-line type of theory of defense instruction. And I'm erring on the side of caution and allowing more information in as much detail as possible to capture the essence of the theory of defense. But based on the case law, an argument could be made that some of this information should be, that I have in here should be taken out. But Ms. Nelson, I'll give you an opportunity to tell me whether you want the suggested language or you want something along those lines or something else.
Leave it as is, Your Honor.
Okay.
And could you remind me, so I can stick it back in my packet in the right place, when the court intends to give the theory of defense instruction?
It's right before the insanity defense.
For the insanity.
I think it makes sense to put it right there. And then right after that, then the next instruction is the insanity instruction. It says the evidence in this case has raised the defense of insanity as a defense to all the charged offenses and lesser included offenses.
Okay, if I can just have a moment to
Yes.
reinsert it into my packet. Okay.
All right, any other instructions? Anything else that you want to talk about with respect to any of the other instructions?
Yes, Your Honor. So now I would like to discuss the proposed, the court's proposed changes to that last instruction regarding the verdict form, as well as the specific proposals that I submitted as part of D-292, which I understand that the court struck, but I'd like to make an oral argument in court.
Yes, you can make an oral argument.
So
let's take the last instruction first, or I guess that they're together, so you go ahead and discuss them
okay.
in conjunction with each other.
And I guess I just want to make sure that I'm making an adequate record about this, and that was my sole intention in filing these pleadings. And I would ask the court to reconsider the order it issued over the break in C-212, striking these pleadings. And if I could just explain, my understanding is that we are I understand what the court said at the beginning of the trial, that we're supposed to be making motions in open court. And we've done that, and we've done argument in open court, and I understand all of that. But I have to make sure that I'm providing Mr. Holmes with effective assistance of counsel, and that I'm complying with the ABA guidelines for the appointment and representation of defendants in capital cases, and that I am making as complete an appellate record as I can. And
you are. I'm giving you an opportunity to do it orally. The problem with doing it in writing is then I have an obligation to go look at it in writing, and I'm not going to have time today. It's 10 till 12. We have 165 verdict forms. I have 60 some odd pages of instructions. I have to finalize these. I have to make 24 copies of everything. Well, not all 165 verdict forms, but I have to make 5 copies or 4 copies of the verdict forms in their entirety. And it's not 164 because each verdict form has 3 pages, so it's almost 500 pages. And we're having closing arguments tomorrow. So by doing it this way at the last minute, it doesn't give me an opportunity to just to review it, to allow the people to file something in writing to respond, and to have me rule on it. So that's why we have to do it orally. We're here talking about it orally. If you make a request, or if you make an argument, or if you make some kind of record, I'm here right now and I can tell the prosecution, what's your position on that? And then I can rule. And then if you have another record to make or another position to make, then you can make it, and I tell the prosecution, what's your position on that? And then I rule on it. And that way the record is complete. But to do it any other way, then creates a record that is unclear and a record that is dangerous on appeal, because then what it looks like is all these records and arguments that you may have made in your written filings that I did not have a chance to review, and yet someone on appeal will say, well, the record was preserved, the judge just didn't rule on it. And that's not accurate, and that's not appropriate. So if you have something to say, bring it up with me right now. I'll give the prosecution a chance to respond, and I'll rule on it. But you can't just file something just to have it on file. We have had now, this is the 3rd jury instructions conference. You've had my draft, the draft that I gave you on July 2nd, you had that one for 8 days before we talked about it on July 10th. So you had plenty of time to look at it, to consider that draft, to figure out what else you needed to file. I did not limit you in terms of what tendered instructions you submitted either before the first jury instructions conference on June 24, or before the last one on July 10. But to come in today when I'm expecting to just finalize the instructions and have a voluminous filing with new tendered instructions, that's not appropriate, especially when the pleading that is attaching or that has attached all those new tendered instructions appears to have some record made about different things. I can't, that's just not a good way to proceed. So we have to do it this way. So make your oral record, and then I'll give the people a chance to respond, and then I'll rule. So with respect to this instruction, my recollection with respect to the last instruction is that your main concern had to do with the issue in Bailecki and Collins and the statute that I cited earlier. And I changed it over the weekend. Of course, you didn't know that because I did it over the weekend, but I changed it in accordance with what I felt was your concern. I'm not saying that you've waived anything, but to the extent that you've submitted newly tendered instructions that address that issue, I believe the issue has been addressed. And that's another problem with submitting things without getting leave of court, is that you're submitting something, and yet I made a change. If someone sees the two, they're not gonna get what's going on. They're gonna be confused when someone's reviewing the record. And so I think this is the clearest and cleanest way to go. The changes I made is to make clear to the jury that they are to consider the evidence and the law separately and independently with respect to each count. I've repeated that concept that was already in an instruction. I've repeated it in the last instruction. I've reminded the jury of it. And I've said to the jury, so even if you find him guilty of one count, that doesn't mean you have to find him guilty of any other count. And even if you find him not guilty of one count, it doesn't mean you have to find him guilty of another count. And that applies even if the reason for the not guilty finding is solely based on the prosecution's failure to prove beyond a reasonable doubt sanity. That's all in there now. I've also added the parenthetical information that you wanted, reminding the jury what Part B of each verdict form is about and what Part C, well, I did Part C on my own just to be consistent. But so I did all that based on the discussion that we had Friday. So as constituted, what is your position on this last instruction?
We don't, as constituted with respect to the last instruction, I don't have an issue or a problem with what the court added. However, it doesn't cure the constitutional problems that I see with the instructions in the verdict forms in general. And I would like to explain why to the court, if I may.
Yes.
And in doing so, I may read directly from D-292 just to make sure that I'm articulating myself clearly.
Just as long as you read slowly so that my court reporter can follow along and I can follow along.
I will, Your Honor. Just to put this into context, just to explain to the court where I was coming from and why I proceeded in the fashion that I did. Our original position before the charging conference that we had on Friday, July 10th, and was and continues to be that the verdict form separated out into a Part A and a Part B, setting aside the issue of whether the jury completes Part B for every count or not, is that the court's draft verdict form, which provides the jury with only two options, guilty or not guilty, in Part A of the form, and then proceeds to inquire about the basis of a not guilty finding in Part B of the form, violates Mr. Holmes' state and federal constitutional rights to due process and a fair trial by an impartial jury under the 5th, 6th, 14th Amendments to the United States Constitution, as well as Colorado Constitution, Article 2, Section 25, as well as the heightened reliability required by the 8th Amendment and Article 2, Section 20 of the Colorado Constitution, because the verdict form does not clearly convey to the jury that it has the third option of finding Mr. Holmes not guilty by reason of insanity, and thus enhances the risk of an unwarranted conviction under Beck versus Alabama.
All right, let's take it one by one. So the people want to respond to that. We've talked about it, but anything that the people want to add with respect to that issue?
I think we adequately covered that on Friday.
I think so too, and I'll repeat again, I am bound by Colorado law. This is what Colorado law specifically requires me to do. This is how the model instructions suggest that I do it. I'm doing it consistent with Colorado law and the model instructions, and so I incorporate by reference the record we made on Friday with respect to this particular issue. Okay, what's next?
Okay, so that was our position going into the charging conference on Friday, that our proposed verdict forms, which give the jury just three simple separate options, not guilty, not guilty by reason of insanity, or guilty, are required by due process and the other constitutional provisions that I just cited, including heightened reliability under the 8th Amendment, Article 2, Section 20 of the Colorado Constitution. Under the 8th Amendment and Article 2, Section 20 of the Colorado Constitution. So after it became clear that the court disagreed with that position that we took on Friday, excuse me, hold on one moment. And continue to take. Then we moved on to discussing the second issue and concern that we have with respect to the verdict forms, which is that the jury only fills out Part B of the verdict form if they find Mr. Holmes not guilty of all of the counts. And so it was in relation to that discussion that I was concerned that things got a little confusing and that I didn't provide specific enough direction and request in terms of what we were asking for. And so that's why, after reflecting on the conference that we had over the weekend, I thought it would be prudent to give the court very specific language about that addresses the issues that we have remaining with the verdict forms.
But you've had these verdict forms since July 2nd, and I specifically made a record about this issue on July 2nd and told you both that I was doing it this way because it's required by Colorado law, and said Bielecki requires it, Collins requires it, and 16-8-105.5 subsection 3 requires it. So even though we had not actually had a discussion about it until Friday, July 10th, I had already told you that this is the way I was doing it and why. I had told you I'm doing it this way because I'm required by law, and you both looked surprised, and I gave you the authority so you could go look at it. So to the extent that you wanted to file any tendered instructions, they should have been filed on July 10 when you filed the other second set of tendered instructions that you filed. But at this point, I'm more interested in moving on. I mean, I have ruled that we're going to proceed orally, and I have explained why, and I think anyone reviewing this record will understand why I'm doing it this way. I think it's the cleanest way. It's the only way to do it, in the cleanest way. It's the only way to do it in order to have a clean record and a record that's clear. So in terms of the point about the jury only filling out Part B of the verdict forms, if the jury finds the defendant not guilty of all the charges and all the lesser included offenses, that's pursuant to Bielecki, Collins, and 16-8-105.5 subsection 3, and I incorporate by reference the comments that I made on July 2nd and on July 10. What's next?
Okay, if I can just make an additional oral record about this.
Yes.
And the reasons why we are concerned about the way that the draft verdict forms and instructions are written. We're concerned that they direct a verdict on all counts as to the issue of sanity in violation of Mr. Holmes' state and federal constitutional rights to due process and trial by jury, as well as the heightened reliability required by the 8th Amendment and Article 2, Section 20 of the Colorado Constitution, because the instructions and verdict forms effectively convey to the jury that a finding of not guilty by reason of insanity is an all or nothing proposition, and that a finding of guilty on any one count negates the possibility of finding Mr. Holmes not guilty by reason of insanity on any other count. And if the instructions and the verdict forms are given to the jury as they are written, the jury will have the impression, notwithstanding the edits that the court made to the instructions over the weekend, that it is precluded from being able to return a not guilty by reason of insanity verdict on appropriate counts, and instead must choose only between guilty and not guilty verdicts unless it finds the defendant not guilty by reason of insanity on all counts, which also increases the risk of an unwarranted conviction under Beck versus Alabama. And then separately and additionally, given the facts and circumstances of this capital case, it is constitutionally necessary for the jury to complete Part B of the verdict form for each count, regardless of its verdict on any other count, so that the jury can give full effect to its verdict on each count. I would note that the rationale under Bielecki and Collins is that it is unnecessary for the jury to complete the special interrogatory on insanity, which is Part B of the verdict form, if a defendant is found guilty of any of the felony counts, because a guilty verdict on any count subjects the defendant to incarceration in the Department of Corrections, and the jury's reasons for finding him not guilty on any other charge are no longer important. But the distinction is that in this capital case, that justification is subordinate to the jury's need to render a full and complete verdict on each individual count for purposes of evaluating whether Mr. Holmes should be sentenced to death. In addition, the Colorado Supreme Court must review the propriety of any death sentence, and the propriety of any death sentence will necessarily require an evaluation of the actual verdicts rendered on each count. And the jury's actual verdict on each count is likewise necessary to assess the reliability of any death sentence that could potentially result in these proceedings, and therefore a complete and accurate verdict form for each count specifying whether the jury has found Mr. Holmes not guilty or not guilty by reason of insanity is required by the Eighth Amendment in Article 2, Section 20 of the Colorado Constitution. And I would cite to Beck, People versus Young, 814 P. 2nd, 834, Colorado, 1991, as well as People versus Tennyson, 788 P. 2nd, 786, Colorado, 1990. And I would also just note that neither Bielecki, Collins, nor the statute appears to have contemplated the type of charges that we have in this case, which include multiple Class 1 and Class 2 felonies of first-degree murder and attempted first-degree murder, as well as a single Class 4 felony of a different nature that was allegedly committed at a different time and location, which is the possession of the explosives or incendiary devices. And so if the jury were to find, hypothetically, Mr. Holmes guilty of the explosives count, which is a Class 4 felony, and not guilty by reason of insanity on the murder and attempted murder counts, but didn't specify in Part B whether or not its not guilty verdict was based on a finding that Mr. Holmes was insane, Mr. Holmes would be sentenced to the presumptive range of 2 to 6 years on the explosives count and then released into the community. Whereas if the jury were to make the same findings and did complete Part B for each count, then presumably following any sentence of incarceration that he serves on the Class 4 felony, he would be or could be committed to the Department of Human Services as a result of the not guilty by reason of insanity verdicts on the Class 1 and 2 felonies. And so it does matter in this case, just given the way that the charges have been laid out. And in fact, that was precisely the result in the Eastwood case that I mentioned on July 10th on Friday. He was acquitted of the greater accounts and convicted of a lesser account and was sent to the state hospital because he had received credit for time served on the lesser charge that he was found guilty of. I don't mean greater and lesser as a lesser included. I mean there was a more minor felony charge as well as greater felony charge. So that's the basis for the proposed changes. And if I can quickly just put on the record what those proposed changes are. And I again would object to doing this orally only because I think it's important for an appellate court to be able to see precisely how we're asking to amend these instructions so that it's to avoid confusion for the appellate record. But understanding the court has denied that request, I will proceed orally. The first would be to the elemental instruction on murder in the first degree after deliberation. Our request would be to make the following additions to the last paragraph. It currently reads, after considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, and then we would add, including element 7, which pertains to the defendant's sanity, you should find the defendant not guilty of that count in murder in the first degree after deliberation, and you should so state in Part A of the verdict form for that count. So that actually the court, even if the court disagrees with my position about having the jury fill out Part B of the verdict form for each and every count, I think the court can and should add that language into each elemental instruction to make it clear that how they give effect, how the jury should give effect to a not guilty by reason of insanity verdict.
So you want me to add, including element 7, which pertains to the defendant's sanity?
Yes.
Okay. All right, and to the extent that you're asking me to make the same change in other instructions, you can just say, make the same change in instruction, blah, 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 so you don't have to repeat everything.
Okay, will
Okay?
do. And then,
By the way, once we've gone through them, then if you want to submit them in written form, you can. All you have to do is ask for leave of the court, and I will grant you that request. Of course, I understand that anyone reviewing this record on appeal would want to have them in writing, but I want to make sure that that's the only difference between the tendered instructions that you're talking about now and the ones that I have received in the past, because I'm not going to have a chance to review these today, given that I have to finalize the instructions and make all the copies and get ready for tomorrow for closing arguments. Does that make sense?
that does make sense, Your Honor. And given, and I can tell the court too that.
But when you file them, by the way, I apologize, Ms. Nelson, when you file them, I don't need a pleading explaining anything. Just file them. All I need is a one-liner saying, here are the additional tendered instructions that the court gave us permission to file pursuant to the discussion we had on July 13th. I'm not asking for any other record, argument. The time to make records and argument is here while we're all here talking because of the time limitations that we have. Okay, go ahead.
I understand that, Your Honor. Actually, I was just going to say that one of the reasons that I did put into writing what our objections and concerns with the verdict forms are is because having done a lot of appellate cases, I wanted to make sure that for an appellate court or any appellate attorneys who are reviewing the record, it's just not totally out of context or they're confused about what this is, because sometimes you review the record separately from the transcript and it's not immediately apparent like how the two connect. And so I would ask the court for permission to just refile this now that I've essentially read it into the record, just so that someone who's looking at the appellate record later understands what this is and why, what its purpose is.
No, you can refile the instructions themselves. To the extent that you've made the record, we've talked about that record here, and we're still talking about the record. So to the extent that that pleading includes any assertions or arguments or requests or records or any commentary, I am reacting to it here after I give the prosecution a chance to respond. So they can read the transcript. I'm sure those folks are equally good and adept at reading transcripts as they are motions. Now, to the extent that you want to submit the actual instructions, if you're representing to me that the only difference between the ones you're submitting now and the ones you've submitted before is the language that you're referencing now, then I will take you at your word and you can resubmit them after we have had the discussion here. So go on. What other instructions are you asking me to add that language to?
So I would ask, well, first I have one additional sentence that I would request that the court add to the end of that paragraph in the elemental instruction that states, you should then proceed to complete Part B of the verdict form for that count, which inquires whether you found the defendant not guilty on this count solely based on the defense of insanity. I understand that the court is likely to reject that language based on the court's position regarding Bilecki and the statute, etc., but that's the request that we would make. So just to summarize, to make it clear, the last paragraph, there are two modifications that we're asking for. The first would be to state, including element 7, which pertains to the defendant's sanity, in that first paragraph, discussing whether what the jury should do if it finds the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt. And then the second change would be to add that sentence that I just stated. You should then proceed to complete Part B of the verdict form for that count, which inquires whether you found the defendant not guilty on this count solely based on the defense of insanity.
Okay. What other instructions are you asking that these changes be made to?
Okay, so that change applies to the elemental instruction on first-degree murder after deliberation. It also applies to the elemental instruction on the lesser included offenses to murder in the first degree after deliberation. It also applies to the elemental instruction on murder in the first degree extreme indifference. as well as the elemental instruction on the lesser included offenses for first-degree murder, extreme indifference. It applies to the elemental instruction with respect to the charges of attempt to commit murder in the first degree after deliberation, as well as the elemental instruction on the lesser included offenses of attempt to commit murder in the first degree after deliberation. It applies to the elemental instruction on the offense of attempt to commit murder in the first degree extreme indifference, as well as to the elemental instruction pertaining to the lesser included offenses of attempt to commit murder in the first degree extreme indifference. It also applies to the elemental instruction on count 141, which is possession or control of an explosive or incendiary device, and the elemental instruction on that.
Okay, great. All right, do the people want to respond?
We object, Your Honor. We think the instructions as currently constituted accurately depict the law or describe the law, and these would not.
Well, I've made an extensive record on this point already, both on July 2nd and July 10th, as well as today. And I had to follow the law, and the law in Colorado is clear. Let me read to you from Colorado Revised Statute, Section 16-8-105.5, subsection 3. When the affirmative defense of not guilty by reason of insanity has been raised, the jury shall be given special verdict forms containing interrogatories. The trier of fact shall decide first the question of guilt as to felony charges that are before the court. If the trier of fact concludes that guilt has been proven beyond a reasonable doubt as to one or more of the felony charges submitted for consideration, the special interrogatories shall not be answered. Upon completion of its deliberations on the felony charges as previously set forth in this subsection 3, the trier of fact shall consider any other charges before the court in a similar manner, except that it shall not answer the special interrogatories regarding such charges if it has previously found guilt beyond a reasonable doubt with respect to one or more felony charges. The interrogatories shall provide for specific findings of the jury with respect to the affirmative defense of not guilty by reason of insanity. So this statute requires me to give the jury special interrogatories or special verdict questions asking them if the reason that they found the defendant not guilty is based on the insanity defense or not. But it also tells me that I have to tell the jury that the jury should not answer those questions, should not answer any of those interrogatories if they find them guilty on any felony charge, and that the way that the jury should proceed is that the jury should first decide guilty or not guilty, in other words, the issue of guilt, with respect to all the felony charges, and that the jury should only get to the interrogatory or to the special verdict form, if you will, the special verdict question, if you will, if and only if they find the defendant not guilty of everything. That's what I'm doing. I don't have a choice here. I took an oath to uphold the law, and there's no exception in the statute to a case where the prosecution is seeking the death penalty. There's no exception in the statute at all. The statute says this is how we have to proceed, and I'm proceeding pursuant to the statute. Furthermore, there's a case from the Colorado Supreme Court, People versus Collins. I've cited it before, that says this is how I have to do it. There's a case from the Colorado Court of Appeals, People versus Bailecki, that says this is how I have to do it. I have to follow the law. I'm following the law. Oh, and one more thing. The model instructions, which are there to provide guidance to the trial court, says this is how you should do it. I'm doing it consistent with all those authorities and consistent with the model instructions. And, you know, if counsel, based on the concern expressed by Ms. Nelson, I added some language to the last instruction to repeat the same thing that a different instruction already talked about. And we already had an instruction on multiple counts. The multiple counts instruction already tells the jury that there are multiple counts in this case, and explains to the jury that a separate offense is charged against the defendant in each count. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately and influenced by your decision as to any other count. The fact that you may find the defendant guilty, not guilty, or not guilty by reason of insanity of one of the charged offenses should not control your verdict as to any other charged offense against the defendant. The defendant may be found guilty, not guilty, or not guilty by reason of insanity of any one or all of the charged offenses. This is not a case where I have included the type of language that was problematic in Bailecki and that led the defendant to argue that it was essentially a directed verdict, or that it called for a directed verdict. I have avoided that type of language. Not only have I avoided the type of language that the trial court included in the instructions in Bailecki, but I have actually gone out of my way to make it clear to the jury that there is a difference between, on the one hand, being able to find the defendant guilty, not guilty, or not guilty by reason of insanity with respect to any count, and on the other, us only caring about the reason for the not guilty verdict if they find him not guilty of everything. And so, you know, on the one hand, it's clear, and by the way, in the final instruction, it's even more specific, because there I have made it more detailed, more specific with respect to including the lesser included offenses. The language there is, therefore, the fact that you may find the defendant guilty of the charged offense or a lesser included offense in a count should not control your verdict as to the charged offense and lesser included offenses in any other count. Similarly, the fact that you may find the defendant not guilty of the charged offense and the lesser included offenses in a count should not control your verdict as to the charged offense and the lesser included offenses in any other count. This is the case even if the reason that you find the defendant not guilty of the charged offense and the lesser included offenses in a count is solely based on the prosecution's failure to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act. That language addresses Ms. Nelson's concern about a directed verdict, or her concern that the jury is going to think that in order to find him not guilty by reason of insanity of any count, they have to first find him not guilty by reason of insanity of all the counts. That language takes care of that concern. Now, having said that, then the next paragraph explains to the jury, if you find the defendant guilty of any charged offense or lesser included offense in any count, you should disregard Part B of all the verdict forms. That language is going at what they should fill out and what they shouldn't fill out, not what they should find or can find or should not or could not find. That's the distinction. We only care about the reason for a not guilty verdict on a particular count if the jury finds the defendant not guilty of all the charged offenses and all the lesser included offenses. But that doesn't mean that if the jury it's an all or nothing proposition in terms of what the jury can find in this case. So for all those reasons, and by the way, counsel, as I've said before, can explain this in closing argument, and they can clarify it. You know, counsel are entitled to provide comment on the instructions. The instructions don't need any clarification. But if counsel believe they need to make sure the jury is clear on this, they can get up and talk about it as long as what they say is consistent with the instructions. So, for all those reasons, I continue to believe that the instructions as constituted are appropriate and the request is denied. Ms. Nelson, what else?
Next would be a proposed change to the instruction about the affirmative defense of insanity. And I should make clear, if it's not already clear, that the changes that I'm proposing right now are just, these are additional changes that are based only on this verdict form issue, and I'm not waiving any objections or proposed changes that we've previously discussed at the other two charging conferences.
Okay.
It's on page 3, and it's at the end of that at the end of the paragraph that
the last paragraph of the
spills over from page 2 onto page 3. So it says, if you decide that the prosecution has failed to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act alleged in a charged offense and in its lesser included offenses, you must find the defendant not guilty of that charged offense and of its lesser included offenses. In that event, you should have the foreperson sign on the designated line in Part A of the verdict form for that count to indicate your verdict on that count. And then our proposed additional language would be, you should then proceed to complete Part B of the verdict form for that count, which inquires whether you found the defendant not guilty on this count solely based on the reason, or solely based on the defense of insanity.
Okay. Do the people want to respond?
Objection, Your Honor.
All right, same objection, same ruling. Again, it's going to be clear later, not only in the instructions, but in the verdict form as to when they fill out Part B of any verdict form. And that is, they either fill out Part B of all the verdict forms or they fill out Part B of none of the verdict forms. What else?
So the next instruction is that we are proposing changes to is the one that starts out, I think it starts out, if you find the defendant not guilty of all the charged offenses and lesser included offenses, you should answer the following verdict question in Part B of the verdict form for each count.
No, it starts out with, if you find the defendant guilty of any charged offense or lesser included offense in any count, you should disregard the remainder of this instruction as well as Part B of all the verdict forms.
Right, yes, that's the one I'm talking about. Okay. The reason I got confused is because our proposal is to omit that first paragraph. So our proposed revision would be to omit that first paragraph, and then in the second paragraph, take out the word however, and change all to any of. So it would read, if you find the defendant not guilty of any of the charged offenses and lesser included offenses, you should answer the following verdict question in Part B.
Okay, do the people have a position?
Object.
Same objection, same ruling, same issue. This is by Leckie, Collins, and the statute that I read from a moment ago, 16-8-105.5, subsection 3.
And then the final instruction, and then I have proposed revisions to the verdict forms as well. The final instruction would be the instruction that states following the parties' closing arguments.
Yes.
And then, so we would ask the court in the third paragraph, where it says, you should indicate your verdict on each count in Part A of the verdict form. If you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, we would ask the court to include the following language, including element 7, which pertains to the defendant's sanity, then your verdict on that particular count is not guilty, and you should have the foreperson sign on the designated line in Part A of the verdict form. And again, this edit or this requested revision, I don't think it conflicts with the court's position on the Bilecki issue, but it just makes it clear how they give effect to a not guilty by reason of insanity verdict.
By saying including element number 7.
Yes.
All right, Mr. Orman.
I don't think that's necessary, Your Honor. I think the instruction that is currently constituted accurately conveys the duties of the jury.
I agree, and furthermore, I think it highlights one element over all the other ones, and I don't think that's appropriate. So,
and then
the request is denied.
Sorry. May I proceed?
Yes, go ahead.
And then on the second page, we would ask the court to omit that paragraph that begins, if you find the defendant guilty of any charged offense or lesser included offense, you should disregard Part B of all the verdict forms. So we would ask to omit that entire paragraph and instead add a paragraph that states the following.
Are you on the old draft or the new draft?
Oh, I'm on the old draft.
Okay.
That's why. I'm on
Well, the
old
new draft reads differently than the one you're working off of now. So the last paragraph that you read also didn't track the new draft, just FYI.
Okay, let me pull out the new draft. I think I can,
Because on the last one that you just, let's go back to your request to add including element 7 or something along those lines. Which paragraph is that on?
let me look at I'll look at the new draft and then
Okay.
we can work from the new draft. So the new draft, it would be, no, it would be the same, actually, for that first change.
It's the third paragraph, right?
Mm-hmm.
And then which sentence? Second sentence? If your verdict on account is not guilty of the charged offense and the lesser included offenses, you should have the foreperson sign on the designated line in Part A of the verdict form for that count. That's the sentence where you want to add that, including element 7 language?
Yes, and I guess we would ask that it be phrased in terms of the prosecution failing to prove any one or more of the elements beyond a reasonable doubt. So it would read, you should indicate your verdict with respect to each count in Part A of the verdict form. If you decide the prosecution has failed to prove, and then instead of the sentence that the court has in the new draft, it would read, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, including element 7, which pertains to the defendant's sanity, then your verdict on that particular count is not guilty, and you should have the foreperson sign on the designated line in Part A of the verdict form for that count.
And so then the next line, are you proposing to change it so that it reads, if you decide that the prosecution proved beyond a reasonable doubt all the elements, then your verdict is guilty?
That would be fine.
Okay, yeah, I don't think it's necessary, so my ruling stands. I think that that point is made throughout these instructions, and this last instruction is just talking about, in general, how to fill out the verdict forms, so.
Okay.
What else?
So then on the second page, I don't have an objection to the paragraph the court added that begins as mentioned earlier in these instructions, so I don't object to that addition.
Okay.
But I continue to object to the next paragraph that begins, having said that, if you find the defendant guilty of any charge, blah, blah, blah.
Okay.
So instead, I would ask that instead of that paragraph and the paragraph that follows, that the court omit those two paragraphs and instead include a paragraph that states, if you find the defendant not guilty on any count, you should then proceed to complete Part B of the verdict form for that count, which inquires whether you found the defendant not guilty on that count solely based on the defense of insanity.
People's position? All right, same objection, same ruling, same issue under People versus Bailecki, People versus Collins, and Colorado Revised Statute Section 16-8-105.5, subsection 3. What else?
And then, working from the new draft, it would be the third page of the instruction. The final paragraph that begins, if you conclude that the verdict question in Part B of all the verdict forms should be answered, we would ask the court.
Wait, where are you? I'm sorry.
I'm sorry, it's the last paragraph of the third page of that instruction.
That starts with, you will be provided with 165 verdict forms?
No, the page before that.
Oh, sorry. If you conclude that paragraph?
Yes.
Okay, go ahead.
We would just ask the court to change of all the verdict forms to of any of the verdict forms.
Okay.
For the same reasons that we've previously stated.
All right, the people's position? All right, same, issue, same ruling, same objection, same ruling, again, under People versus Bielecki, People versus Collins, and Colorado Revised Statute, section 16-8-105.5, subsection 3. What else?
Okay, that's it for the instructions.
Okay,
And then with respect to the verdict forms,
all right, let me get those, hold on. All right, let's work on the newest, on the most recent draft that we distributed this morning. All right, go ahead.
let me just make sure that there aren't any differences between the drafts that I was working from and this draft.
There may be differences that are, in my view, not substantive.
So the requested change would be, instead of, if you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave Part B of all of the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. We would propose or request that it be changed to read, if you found the defendant guilty of the charged offense or a lesser included offense in this count, you should leave Part B of this verdict form blank. If, however, you find the defendant not guilty of the charged offense and lesser included offenses in this count, you should answer the verdict question below, which would give effect to our request that the jury fill out complete Part B for all of the counts, regardless of whether they found him guilty on any other count.
The people's position?
We object.
Same objection, same ruling, it's the same issue, it's Bielecki, it's Collins, it's Colorado Revised Statute, section 16-8-105.5, subsection 3. And the record will reflect, by the way, that Ms. Nelson's position is consistent with the way I had initially drafted the instructions in the verdict forms. And then I after researching it further, concluded that I was wrong. And I corrected it based on Bielecki, Collins, and 16-8-105.5, subsection 3. And then I also concluded that this is consistent with the model instructions, which my first draft of the instructions was not. It was not consistent with the model instructions. And so, just for the record. All right, what else, Ms. Nelson?
And just for the record, Your Honor, our position is that this breaking the verdict form into, we continue to maintain our objections to breaking the verdict form up into Part A and Part B in general. And we continue to maintain that the only constitutionally compliant way to do it is to do it the way that we proposed. But I'm making these proposed changes based on my understanding the court has rejected that request.
Yes, and I have done it based on the authority that I have cited, Bielecki, Collins, and 16-8-105.5, subsection 3. The statute, I read it a moment ago, specifically tells me to proceed in this fashion. It specifically says, Judge, you need to break it down into two. One part of the verdict form needs to just address guilty or not guilty. And then there should be a question or interrogatory that's separate. And in that question, the jury should be asked, if you found the defendant not guilty, is the reason you found him not guilty solely based on the prosecution's failure to prove beyond a reasonable doubt his sanity? And that's the way I've done it. So, what else?
And that is it, Your Honor, with the understanding that our request regarding Part B of the verdict form applies to all of the different verdict forms on all of the different types of counts that were included in the court's proposed draft verdict forms.
Got it. That's all 165 verdict forms.
Yes.
Okay.
Yes.
Anything else?
Just one more thing, and this relates to the pleading D-291 that the court also struck. And just to be clear, the only reason I included this language in the pleading that these renumbered instructions were attached to was to make sure that I was constitutionalizing everything and preserving everything with respect to Mr. Holmes's constitutional rights with respect to these jury instructions. And so if the court has decided to strike that pleading, I would just request an opportunity to state orally the constitutional provisions that were proceeding under, as well as just to make sure that I'm making all of the arguments that I need to be making with respect to the jury instructions globally.
I have stricken D291, so I am not considering it. I have not, that's not part of the record. So any record that you want to make it orally now, and I'll give you an opportunity to do that. Every opportunity that you want, I'll give it to you. So
Okay.
no time limit. You make whatever record you want to make. To the extent you make any requests, I'm gonna ask the prosecution to take a position, and then I'm gonna rule on it. So go ahead.
So for the record, I would just like to state that we have submitted all of the jury instructions that we have submitted thus far at this point in the case pursuant to Mr. Holmes' state and federal constitutional rights to due process, a fair trial by an impartial jury, his right to counsel, and the right to a fair and reliable sentencing proceeding as protected by the 5th, 6th, 8th, and 14th Amendments in Colorado Constitution, Article 2, Sections 16, 18, 20, 23, and 25, that we maintain our request that the court inform us of any specific objections to incorrect or poorly drafted portions of instructions and assist us in drafting correct substitute instructions. That
Hold on, let's take that one at a time. You said that you maintain your request that the court inform you of any specific objections to incorrect or poorly drafted portions of the instructions and assist you in drafting correct and substitute instructions. I don't remember you making that request before, but.
we did make it with respect to the theory of defense instruction.
Okay, well, that's with respect to that instruction. It's one thing to say, we might maintain our record with respect to our theory of defense instruction. It's another thing to say, we maintain our record with respect in general to any objection. First of all, the court doesn't make objections, so I'm not sure what that refers to. But secondly, the court is under no obligation to specify for you anything. We've had a conversation about instructions. When there was an instruction that you proposed, we discussed it. I addressed any reasons that you stated on the record. I addressed any objections that there may have been by the people. When there was an instruction that was included in my draft, we addressed it. I gave you every opportunity to address whatever was in my instruction, whatever objections you had, and whatever arguments you wanted to make, whatever suggestions you wanted to make. And I gave the people an opportunity to be heard in that too, and I ruled on it. So to the extent that you're maintaining the record that you made with respect to the theory of defense instruction, I understand that, and you are maintaining that record. To the extent that this refers to something else, I'm not sure I follow you. So which is it? And if it's something else, then I need to know more about it.
I think we can move on, Your Honor.
Okay, so you're making this record with respect specifically to the theory of defense instruction?
And also based on my previous recollections of arguments that I have made orally, but I understand that the court may not have the same recollection that I do.
Well, I don't remember, but to the extent that you've made it, what exactly is it that you're asking of the court?
Well, I don't have anything further to say on that point, Your Honor.
Okay, do the people have anything on this point?
No, Your Honor.
Okay, without anything else from defense counsel, we'll move on. What's next?
Just that we continue to move this court, or ask that the court, I should not say that, I should say, we ask the court to instruct the jury completely and accurately in language understandable to the average juror on all of the issues presented by this case. And we assert Mr. Holmes's rights to trial by jury and to due process under the 8th Amendment to complete and accurate jury instructions on all legal principles involved in this case. And we incorporate these constitutional provisions as support for every jury instruction we have tendered. And that's it.
Any response from the people?
Sounds like that's just a request for accurate jury instructions, which I think is what we have.
Yes, I have done my best to make sure that the instructions are complete and to make sure that the instructions are accurate. To the extent that either side has disagreed with me, I have listened to both sides and given both sides an opportunity to tell me specifically what parts of the instructions they think are inaccurate or what parts of the instruction they think are incomplete. To the extent that this is a request related to the information in the instructions being understandable to the average juror, again, these instructions are based on my understanding of the law, and they are in general consistent with the model instructions. To the extent that council believes there's anything in these instructions that is not clear or that would not be understandable to the average juror, then they have an obligation to tell me about that specifically. I've given them every opportunity to do that, and I have addressed every request that has been made, every objection that has been made, and every argument that has been advanced. And without anything more specific than that, there's nothing else I can do to address that point other than to say I've done my best to draft the instructions to make sure that they're accurate, complete, and understandable. But to the extent that either counsel on either side disagree or have any concerns, they have an obligation to point that out to me, and I have asked them to do that, and I believe they've done that to the best of their ability. If there's anything else that anyone wants to point to specifically, now is the time to do it. Is there anything else specific that the people want to point to that is either inaccurate, incomplete, or not understandable to the average juror?
No, Your Honor.
All right, Ms. Nelson, anything else that you want to point to with respect to any part of the instructions that you believe is inaccurate, incomplete, or not understandable to the average juror? Anything else than what we've talked about?
May I have just a moment, Your Honor?
Yes.
One more thing to put on the record.
Yes.
And it pertains to the language that we asked for in the first two paragraphs of the lesser included offense instructions, that the language that we proposed essentially conveys to the jury that they do not need to, that the law doesn't restrict the order in which they consider the offenses. And Mr. Orman made a comment on Friday that that there's a statute that was contrary to what we had articulated in the language in our proposed jury instructions, and I just wanted to put on the record I was not able to find any such statute that conflicts with the language that we proposed. I think what Mr. Orman may have been referring to was section 18-1-408 subsection 8, but I don't think that statute makes Colorado a hard transition state instead of a soft transition state. I think it's clear that the language that we proposed in our submitted lesser included instruction is an accurate statement of the law, and the cases that I cited in the sources section of that proposed instruction are still good case law in the state of Colorado. So I just wanted to make that additional record on that point.
That section that Ms. Nelson just cited, Colorado Revised Statute Section 18-1-408, subsection 8, reads as follows: without the consent of the prosecution, no jury shall be instructed to return a guilty verdict on a lesser offense if any juror remains convinced by the facts and law that the defendant is guilty of a greater offense submitted for the jury's consideration, the retrial of which would be barred by conviction of the lesser offense. Was that the statute that you were referring to, Mr. Orman?
That was, Your Honor, and my recollection of the request from the defendant was that the jury be instructed that they don't have to be unanimous on a greater offense if they can be unanimous on a lesser one. In other words, if there was a disagreement, 6-6 or something like that, to acquit and to convict on murder in the first degree, well, then they should just go to, they can still consider the lesser offenses. That's just not the law. This case, the statute indicates that. That is what the legislature has said. So I maintain my position.
And I maintain my ruling. My ruling was that the instructions as constituted on the lesser included offenses are consistent with Colorado law, and I continue to believe that that's the case. And by the way, they are consistent with the model jury instructions, the criminal model jury instructions as well, which were just published last year. So that request is denied. All right. Is there anything else then that we need to talk about with respect to the instructions from the people?
No, Your Honor. Do you have an estimate as to when we might get a Word draft of this? I'm not talking about all of the verdict forms, but of the modified instructions.
Probably within the next couple of hours is my hope.
Thank you, Your Honor.
Okay. Or maybe within the next hour. I suppose that the ones that you're asking for do not need the blanks filled in, so we could email those pretty quickly. All right. Anything else on behalf of the defense, Ms. Nelson, with respect to the instructions or the verdict forms?
No, Your Honor.
And what I'll do is, once I have them done, we'll email them to both of you. And then once I have the blank spaces filled in, we will have copies for you, and we'll give you those copies tomorrow morning. The order that I intend to put the instructions in is the order that the last draft is in, other than what Ms. Nelson asked for, and that is to move the definitional instruction. So I will move it as I indicated that I would. But otherwise, the order is going to be that, and then the verdict forms, they're just going to be a lot more of what I have shown you. I have shown you, and we've talked about sample verdict forms, 5 sample verdict forms. And there will be a record of it because we're going to put them in the file as well. There are 5 because there are 5 types of charges. We have murder in the first degree after deliberation charges, murder in the first degree extreme indifference charges, attempt to commit murder in the first degree after deliberation charges, attempt to commit murder in the first degree extreme indifference charges, and then the possession or control of an explosive or incendiary device charge. So 5 different types of verdict forms. And those are the ones that we've been working with in terms of the sample forms. Those are the ones we're going to distribute to the jury tomorrow, and that I'm going to go through with the jurors tomorrow morning. But I will finalize and create 165 verdict forms. There are 3 pages to each verdict form, as you know, except for the last one, which only has 2 pages. So we're going to make a copy of all 165 for each party, and then we'll have a copy for the court file as well. Okay, Ms. Nelson?
I just wanted to ask permission for leave of court to refile D-291 and D-292 consistent with the parameters established by the court.
Yes, you can file the number instructions and renumbered instructions. As I discussed, I think 291 is just a renumbering of the first set of instructions, and then the numbering of the second set of instructions that you tendered. Is that correct? Or maybe
yes. Well, I wouldn't technically call it a renumbering of the first set because the first set never had numbers, but I've now assigned numbers to all of the defense tendered instructions.
Great. And then the second set is just a tendering of the instructions that you just ran through here today, and you're representing to me that those were the only changes in those instructions, correct?
The only changes in those instructions that we discussed here today and that don't pertain to other objections that I've made at previous charging conferences.
Okay. So the ones in D-292, the ones attached to D-292, those were newly tendered instructions. And the only difference between those instructions and the instructions previously tendered by you is the changes that you went through and outlined here today?
No, they're not newly tendered instructions by us. What they are proposed edits and revisions to the court's draft instructions.
Okay. And you went through each one of those here in court today?
I did.
In terms of the changes, correct?
In terms of the changes that pertain to the verdict form issue.
Okay, got it.
Not that pertain to other issues that we've discussed at other charging conferences.
Got it. So, yeah, that's what we've been talking about here today in terms of those changes. The Ms. Nelson ran through when she was going through those standard instructions. So I understand, and I've ruled on those after the people have taken a position on each of those proposed changes. So, all right, is there any objection, any other objection that anyone wants to make with respect to the instructions then? And I will have them final for you. Actually, you know what, I'll make that record tomorrow morning instead before I bring the jury in. I'll just show them to you and ask you if you have any other record. I'll ask you if you have any other objection to the order of the instructions, and I'll ask you if you have any other instructions to tender. But with the understanding that there is no other objection, there are no other tender instructions, and these can be finalized now, all right? All right, I think that leaves us with the issue that Ms. Higgs wanted to address, and actually Ms. Titch McGuire has one too. Let's go with Ms. Higgs. You wanted to address an issue with the court related to some unavailability of potential witnesses for a possible sentencing hearing. Obviously, this is not an issue if we don't have a sentencing hearing. It's only an issue if we end up having a sentencing hearing.
Certainly, Your Honor, that's correct.
Okay.
As the court is aware, Mr. Holmes has a right to present all relevant mitigating evidence during the penalty phase of a capital trial. The court is familiar with the Lockett case that discusses that. I think the 8th and 14th Amendments require that the jury not be precluded from considering as mitigating evidence any aspect of Mr. Holmes' character and his background, as do Article 2, Sections 20 and 25 of the Colorado Constitution. And it is clear, and I won't cite a number of the cases because I know the court is familiar with this case law, but a long line of cases indicate that states may only impose the ultimate sentence of death when the court follows procedures that will assure the reliability and fairness of a sentencing hearing. This is the situation that the defense is currently in. 99% of our witnesses for sentencing are coming from out of state. We have cooperation with almost all of these witnesses in their willingness to come and testify. The dilemma falls within the issue of timing. We initially thought that August would be the appropriate time for sentencing. Now that we're ahead of schedule, we've been talking to all of these witnesses about their availability to present evidence in July or testimony in July. And we cannot ask any of these witnesses to basically set aside their entire month of July, August, and September and just wait for the moment that they would be called to testify. I don't think that that's a reasonable alternative. I understand that the court felt that this issue wasn't ripe on Friday, but this is the dilemma that the defense is in. If we come to the end of the sentencing hearing time-wise, and these witnesses are still not available, for example, the court said, well, if we start, July 27th, if they can come the first week of August, then we'd be okay. The problem is if we are not okay, we will not have the opportunity then to introduce any deposition testimony because it won't have been taken. So we are requesting that the court order video deposition testimony taken from certain witnesses, which I will lay out this Thursday and next Monday on the dates that they're available. And we're making this request pursuant to Mr. Holmes' right to due process, right to a fair trial, right to a reliable and fair sentencing hearing, right to present a defense, and right to effective assistance of counsel, both under the United States and Colorado constitutions, as well as Colorado Rule of Criminal Procedure 15. And our goal is to do what the statute says, right, to prevent injustice with regard to Mr. Holmes' right to present mitigation at sentencing in this capital case. All of these witnesses that I'm asking the court to order depositions on are available to come either and prepared to be here on either Thursday or Monday. All of them are to present testimony relating to his character and his background, who he has been throughout his life over different periods of time. We're not asking to do a deposition of any sort of expert or anything of that nature. The first witness we're asking the court to consider, and I want to make clear that the unavailability of these witnesses is based on timing, not based on willingness. The first witness was a roommate of Mr. Holmes during his undergraduate studies at the University of California at Riverside. His life's research has to do with monarch butterflies, and he is living in the mountains doing this research currently, and the time that these butterflies are available to be researched during their migration for him, it happens to fall within this narrow time period. He is available this week on Wednesday and Thursday, and after that he will not be available to August 15th or after August 15th. So there is no time period in what we expect to be the penalty phase, should we reach a penalty phase, that this witness could come testify. And we do not have another witness in his same stature that can provide the same information to this jury.
And what's his name?
The names of all the defense witnesses haven't been released to the media, and in order to give them some protection, especially if the court doesn't allow deposition testimony and they aren't able to testify, I'm happy to give the name to the court at the bench, but I do not want to state them publicly, especially because we're coming up on a potential penalty phase. A number of people have been harassed by the media throughout this case, and I especially do not want to see that happen at this kind of sort of critical time frame. So I'm happy to give the court the name at the bench.
Okay, we'll call him witness number 1 for now. Who else do you have?
Your Honor, the second witness. I just want to number these so I get them straight later. Is a family friend of the Holmes family, and spent time with the Holmes family during Mr. Holmes' younger years, up until about age 12. He has direct testimony as to the Holmes family, how Mr. Holmes was as a young boy, and in his interactions with this witness's young children. He is going to be out of the country starting July 20th and will not return until August 4th. And this is something that's already been paid for, it's already been pre-planned, and it's not something that he can adjust. And he does provide very kind of unique insight into Mr. Holmes' relationship with other children at that young age, and this dynamic with the family and what they did together. The third witness was a neighbor of the Holmes family when he was a young boy prior to moving north to Castroville. We have very few witnesses from that neighborhood at that period of time. It was some time ago, but she has a pre-planned, paid-for trip that goes from July 18th to July 31st. So she would be unavailable during that time period. I don't know if we will get to the week of August, the first week of August, simply because I don't know right now when we're going to start. The fourth witness was Mr. Holmes' teacher in 5th grade when he lived in Castroville. He is leaving the country very, very early in the morning on July 22nd, and so is not available to be here on the 21st. And he will not return until August 8th. Again, this is a pre-planned, paid, out-of-country trip. He is very willing to testify. In fact, most of these witnesses have spoken to the prosecution as well during the investigation of this case. And we don't have any other 5th grade teacher and very few teachers from that period of time to testify with regard to Mr. Holmes and his background and his character. The fourth witness is also a family friend through Mr. Robert Holmes.
I think you said 4th, but I think you mean 5th.
I do mean 5th, thank you. Through Robert Holmes, but this is sort of during this last sort of decade of time. He is leaving the country for work on July 21st. I do not believe that he will be back for the rest of the month. He is currently also unavailable because he is out of the country on work, and so I can't confirm the exact date he will be back, but he is scheduled to be here on Monday the 20th. And the last witness, number 6, that I'm requesting a video deposition of is one of Mr. Holmes' teachers when he was back down in San Diego after coming back from Northern California during 6th, 7th, and 8th grades. He has really reorganized his entire work schedule for the summer. He is actually working during the summer. He's not taking the summer off. Based on our previous estimates of when we may start, and now he can't rearrange any of those work commitments. He is available to us to be here on July 20th, and I don't believe he is available for the rest of the month. And those are the 6 witnesses that we will have here in Colorado on Thursday of this week and Monday of next week, and I can give that breakdown if the court's going to order the depositions. I don't know when we would start a penalty phase if we get there. Our other request would be to set sort of a hard date for that, because it's very difficult with all of these out-of-state witnesses to organize anything at this point in time, because if one day changes, then it kind of pushes everything back, and we have to organize plane travel from the airport, we have to organize lodging, and we've tried very hard to do this within the constraints that we've had set so far, and we're just finding it near impossible to maintain this, especially when we are having to tell these people that we have no idea when exactly they would have to come in. So that is also our second request of the court. Perhaps setting a date where we can be very, pretty sure that we would be there at that point. I would suggest the date of perhaps July 27th. I don't know what the people's position or the court's position is.
But how does that solve the problem with a lot of these people? I mean, some of these people are not available, you're saying. I mean, if we started on July 27th, so what does that solve?
Well, that will not solve the dilemma that these witnesses have, but it will solve dilemmas that we are having with other additional witnesses that we're trying to schedule. It's very difficult to schedule 40 witnesses to fly in and testify the night before we're required to start. And that's basically what the court's asking us to do. It's virtually impossible.
Well, I'm not asking you to do that. That's just the way it works. Do you still have an estimate of 2 weeks for your case, your mitigation case?
Well, I think some of that's going to depend on when it starts and the availability of the witnesses, but that's our current estimate.
Let's assume that you're able to call all your witnesses. Are you still assessing it at about 2 weeks?
That's our current assessment, yes.
All right, and I know that you've endorsed some experts. Do the people, well, I know it's hard for everyone to tell what's going to happen, but do the people anticipate that if some experts are called in mitigation, that they would have experts in rebuttal during that phase of the proceedings?
Most likely, Your Honor.
And so how long do you think that would take?
3 days at the most, I would think.
3 days at the most. So 2 weeks for them, 3 days for you. What's the people's position on the request for videotape depositions? Yes.
Rule 15 is a specific procedure, Your Honor. It envisions affidavits supporting a assertion of unavailability. There is a case apparently that says that affidavits are not essential, and that's People versus Hernandez, 899 Pacific 2nd, 297 from the Court of Appeals in 95. And, but that also says you don't need an affidavit where the court is thoroughly informed of the facts supporting the motion by other means. In this case, Your Honor, the purpose of Rule 15 is that acknowledgement that there are going to be certain situations where it is impossible to comply with the subpoena, or may be impossible to comply with the subpoena, that they are actually unavailable and not inconvenienced. Examples that I've seen are when literally a person's dying of cancer and their doctors say they won't be alive, or most likely won't be alive by the time of the trial. That's one type of situation I've seen. Other situations are when a person literally gets called up to military duty to go to somewhere like Afghanistan, and the military says, "No, you can't have them." Well, there's nothing like, we can't go to the Army and say, "We demand you give us this guy," because obviously the federal government's directives control under the Supremacy Clause of the U.S. Constitution. That person would be unavailable. Everything I've heard from Ms. Higgs indicates that these people would be inconvenienced by compliance with the subpoena, maybe financially inconvenienced by compliance with the subpoena, but not unavailable. They have not, I think, established unavailability as contemplated by Rule 15 for any of these witnesses. And, I haven't even been given the names of these witnesses. I wasn't given a list or anything, and Ms. Higgs talked about doing it up at the bench. But I don't think you can just get up here and say, these people are going to be inconvenienced, let us do a deposition. It deprives the jury of actually assessing the person in person. Although there would be videotape, we all know that there's a difference. It deprives the jury of being able to ask questions, and the rule does not say that that is a dispositive fact, that jury questions would trump this. It talks about unavailability, but I think that it's got to be a reason that
is more than an inconvenience, more than a financial expense, an actual impossibility or close to it to comply with the court's order to appear, i.e. the subpoena. So unless the court has any questions for me, that's what I've got to say on that point.
Thank you. Ms. Hicks, I hear what you're saying. I just don't see how you have established the unavailability of all these people. I mean, it sounds like multiple of these folks have made trips, some of them out of the country, some of them, it sounds like pre-planned, prepaid. Nobody said that we would start any penalty phase, if there is a penalty phase, on July 27th or July 20th. I mean, we've all been doing our best to estimate based on what's happening, but it wasn't until recently that I scheduled closing arguments on July 13, and that changed to July 14. That was about a week ago. And it was about a week or 10 days ago, maybe 2 weeks ago at the most, that we talked about how if that's the case and if there's a penalty phase, then we would start it on July 20th if the jury had deliberated and if the jury found the defendant guilty of any first-degree murder count. I mean, some of these folks, it sounds to me like they have made these arrangements from a long time ago, knowing that there was a possibility that we would be in the middle of sentencing proceedings during this time frame. So I need to know more. I'm not saying no, I just need to know more in terms of why they are unavailable and in terms of the hardship that it would cause them to have to be here to testify in person, in terms of the circumstances they're facing that prevents them from getting here. Again, I understand inconvenience, that's one thing. It's another thing to be unavailable. And so I need more information before I can determine how to proceed. So if you want to provide that to me, I will consider your request at that point. It sounds like most of these folks, we will be able to work around their schedule anyway. But there are a couple of them that sound like, for example, the first witness is available Wednesday or Thursday and then not until August 15. That may be problematic. One of these, you don't even know when the person is back, apparently. You just know that he leaves the country, he or she leaves the country on July 21. So I need to know more in terms of when is the person available after July 21. But the rest of them, with the exception of the first witness, witness number 1, we may be able to work around. The person who's gone, witness number 4, between July 22 and August 8, if the person is leaving on July 22, you know, I'm not sure why he couldn't be here on July 21 or even July 20.
Your Honor, he's scheduled to be, and he's scheduled to be here on July 20th.
Oh, okay.
And the reason we scheduled those, Your Honor, is not because we were hoping that it would be in time if there was a penalty, but also in the alternative that if we weren't there yet, that we would have them present before the court to do videotape deposition because of the unavailability.
Okay. All right. Well, we may be able to work around most of these people's schedules. The first witness number 1, may be the most difficult one, and then I don't know enough about witness number 5 because I don't know when that witness is available again. So the rest of them, witness number 2 is available on August 5th. Witness number 3 is available the beginning of August. Witness number 4, we just talked about, he is available July 20th and perhaps July 21, maybe July 21. I don't know about witness number 5 because I don't know when he's available after July 21. And then witness number 6 is available in early August as well. So it depends on what happens, and it depends on what other information you have that I can consider. But witness number 1 may be the biggest problem. Perhaps witness number 2 as well, because that person would be available on August 5th, and depending on when we start, that may be too late. I don't know. I'm trying to do that may work, depending on when we start. So, but the witness number one is probably the biggest problem. So, but I need to know more, I need to know more in terms of what, is witness number one the same person that you submitted an affidavit with respect to, who's in medical school?
No.
And couldn't make it here? No, that's just somebody else.
Correct.
Yeah, I would need to know more before I can decide whether this is something that I can, that I can grant. So,
Your Honor, we're happy to provide additional information. Could we do that? Can we have leave to do that in writing? We've been trying to contact people to get more information, but some people, like witness number 5, is out of the country right now, and so we haven't been able to determine when he would be available after July 21.
that's fine. I don't need argument, though.
No.
I understand the argument. I just need more information in terms of unavailability.
Okay.
And hardship.
And just so we're clear, Your Honor, part of my point is that if we hope that maybe we'll get there by the time they return, like for witness number 2, if we hope that maybe that will work, that we'll still be in penalty if we get there by August 5th when he returns. The dilemma is, if we're not at that time, we will not have been granted the opportunity to preserve his testimony and then play it. So I think that there are 2 issues. I think the court can order the deposition testimony without necessarily ordering that we will use it. I mean, if it turns out that, for example, witness number 2 does get back in time to come in and give live testimony, then of course the court wouldn't have to order that the deposition be played for the jury. But without having preserved it, we won't have that option. And so I want to make that clear. I would also argue that Mr. Holmes' constitutional rights do trump any right of a juror to ask questions. And I did note within the Colorado Rules of Criminal Procedure, that rule with regard to juror questions has been on the books for many, many, many years. There have been amendments to Rule 15, and the legislature has not ever said that that's a reason not to allow this type of testimony. And if we're able to come up with any alternatives, we will put that in with the information that we provide to the court.
Great. The sooner you get me the information, the sooner I can make a ruling on it. So,
We are doing our best, Your Honor.
great. Okay, as soon as you can get it to me, I will review it, and then we'll go from there.
And with regard to our request to set a hard date to start penalty if we get there, is the court denying that?
Yeah, at this time, I just don't think it makes, I mean, I can set a hard date, but, I don't know that it makes a whole lot of difference. I think we just have to, it's better to stay fluid and flexible and figure out what happens. I mean, I would hate to set it on July 27, only to find out that then we are wasting a week, for example. Or we set it on July 20th, only to find out that we're not gonna start on July 20th because we're not ready to start on July 20th. So it's just, we're all trying to predict, and we're doing the best we can to predict, but it's just difficult to do, so.
We are trying our best, Your Honor. The problem is with trying to remain fluid, it is encroaching upon Mr. Holmes' constitutional rights to present mitigation at a penalty phase in a capital trial. And while if all these witnesses were here in Colorado, it would be much easier to try to remain fluid because not as much would have to be organized and set up. But to ask these witnesses just to be available on a moment's notice for the next 3 weeks is becoming untenable for them, and it is likely that we will lose crucial mitigation evidence to present to this jury in support of a life verdict, and I think that has significant constitutional impacts based on the constitutional provisions I've already cited. And so that is one of the reasons that we're requesting a hard start date. And this is not unheard of in capital cases, that there, even if a couple days we're not presenting testimony, I don't believe it's wasting time. I think it's spending time to ensure that Mr. Holmes' constitutional rights are protected. In addition, we could set a hard start date for testimony for phase 2 and still address, if the jury came back earlier than that with a verdict in the merits phase that required us to move on to a penalty phase, we could move on to instructing the jury and to phase 1, I think is what the court calls it. So I think there's a little bit of leeway in there, but I understand the court's position.
What date are you asking the court to set? What solid date are you asking me to fix?
I think July 27th would be the most reasonable. I think it's most likely that we would have a jury verdict at some point next week. But we could also take a day and address phase one and let the jury deliberate on that before the defense begins presenting testimony on July 27th with regard to phase two evidence.
Are you asking me to set July 27th as the start of any sentencing hearing or as the start of mitigation, phase two?
As the start of phase two.
Do the people have a position on that, Mr. Orman?
I agree with the court's previous assertion or statement that we need to remain flexible at this point. We don't know when a jury will be completed with their jury deliberations for the issues that we've been discussing in jury instructions for today. And if they come back a lot quicker than saying, hey, by the way, you're coming back in a week and a half or a week to hear some more evidence, I think is really unfair to them. And I don't think that Ms. Higgs has demonstrated sufficient facts for the court to conclude that the procedure that we currently have, where we have flexibility, would deprive the defendant of any constitutional rights. Presumably, all these people are under subpoena. They have to come. The defendant hasn't shown, I think, unavailability. So that's all I have to say, Your Honor.
All right, Ms. Higgs, file the information related to unavailability and we'll go from there, okay?
And Your Honor, I think I should also point out in abundance of caution, because the court doesn't want me to add any additional argument to any filings, is that under People versus Hernandez, the court cited by the prosecution, good faith efforts to obtain a witness does not require exhaustion of every possible means of securing the witness's presence. In that case, the prosecution did not have the witness under subpoena, and that was still not the issue. So that's just in response to the prosecution's last argument.
All right, thank you. All right, Ms. Tisch-McGuire, do you want to approach on your issue? And actually, Ms. Higgs, did you want to make a record as to the actual names of these folks so the record is complete?
Yes, I have.
Why don't you do that?
Well, good afternoon now, and what we'd like to do is go picture in picture here. So Andrew, if you punch camera 3 into your background shot on the red line, you're going to be fine there. Perfect. So now we're picture in picture, and we have David Beller, our legal analyst here, and since he's here in person, we're going to take this opportunity during this bench conference to check off of our list a couple of the lessons and questions that have arisen today. And let's first start with the thing that we were just most recently discussing, this process that if guilty, we go to these next 2 phases. Can you give us a little summary of what exactly happens there?
Sure. So what's going to be happening, Phil, is that the prosecution has to establish certain aggravating factors. Right. So they're going to talk about the number of victims, the torturous way that these victims died. The prosecution has to prove these different aggravating factors, and then it's going to switch to the defense. Mm-hmm. And the defense at that point is going to be able to put on all sorts of individuals who talk about the fact that Mr. Holmes really is a good person, or oftentimes a difficult childhood that somebody had, or really reasons why, or perhaps explanations why the crime occurred. And so what the defense is arguing is that many of these witnesses who are able to testify for Mr. Holmes are going to be unavailable. And so they're asking that the witnesses testify via deposition. In other words, the attorneys in a room record the examination. The prosecution is objecting. The defense is saying, without a schedule, we can't get these witnesses here. You have to give us an idea.
Do you have a feeling, a sense in your own opinion of which side is A, likely to win, and B, actually right?
Well, this isn't one of those things where there's a right or a wrong from a scheduling standpoint without knowing exactly when it's going to start. It's impossible for either side to get their witnesses present in the courtroom. Right. The prosecution has the advantage that all their witnesses, or most of their witnesses, are in state. The defense has a disadvantage that most or all of their witnesses are out of state. Mm-hmm. Deposition is pretty unheard of in Colorado. It's very common in other jurisdictions.
It certainly, Mr. Orman certainly made it seem very uncommon. Earlier, we were hearing these debates, word for word debates, and Andrew, they took down our slate, did they? Yep. All right. Well, we'll continue, and sure, either the signal will resume or it won't. But either way, we'll get through and let you get back to your day. Why were they so nitpicky over little bits of grammar, individual words, things like states versus asserts in this discussion of the instructions that the jury is going to be given?
Because oftentimes with these instructions in the law, a single word really does change what the law says or what the case law says. And so oftentimes when a court of appeals or the Supreme Court, either state or federal, is looking at a case and they ultimately end up reversing the case, meaning sending it back to the trial court for another trial, oftentimes it's because of bad jury instructions. It's because the higher court says the jury should have been informed this way instead of this way. Mm-hmm. And so the attorneys are doing 2 things. Number one, the prosecution is trying to make sure that the instructions given have already been approved by a higher court. That's also what the judge is trying to do. The defense, on the other hand, is wanting to make sure that they are objecting to anything and everything they can think of to object to, because ultimately, when a higher court reverses, it's often because of the jury instructions.
I see. They also, the defense that is also objected in a very blanket manner to any language that's not common language and anything that they might have forgotten to object to. How are they allowed to just throw down a blanket, a sheet like that, and just say, oh, and by the way, we also object to everything else?
Well, oftentimes a court of appeals will say, you know what, this is a valid issue that's being raised on appeal. However, it was not preserved in the lower court. In other words, the attorneys at the trial level, such as what we're seeing in court now, didn't object to a certain provision of the Constitution, and therefore a higher court is not going to consider the Constitution when analyzing the issue. So in a more general sense, what that means is this is a catch-all provision. It's sort of like that little asterisk that's on the bottom of your ticket stub that says we will not be held liable. It's the same thing. This is just a catch-all. The defense attorneys are doing everything they can to make sure that they're saying the magic word.
The magic word.
The magic word.
Well, I think the magic word that everyone wants to know is after closing tomorrow, when is a verdict going to come down? I think that's the magic word. And we heard the defense saying they expect to go until the week of the 20th, prosecution not wanting to nail that down. What do you think is likely in a case with 165 counts?
Jurors in Colorado tend to be quick to verdict, different than other states where oftentimes it'll take weeks, if not months, of deliberation. This has been a long trial. I would expect a relatively quick verdict. Keep in mind, it's a lot of counts, but it's a relatively easy and quick issue, that being, did the prosecution prove his sanity or not?
So when you say relatively quick, are we talking about days or weeks?
You know, my best guess, don't hold me to this, Phil, my best guess is we'll probably have a verdict within a matter of days or sometime next week. That would be my guess.
I mean, certainly we are all aware, all of us who are watching this trial, that Monday the 20th would be the anniversary, and that would be, what, the 5th or the 4th day of deliberations. I mean, is that a real possibility? And is the jury going to be aware that they could be making a statement by reaching a verdict in that way?
You know, the jury is certainly aware of the date of offense because it's on all the documents, and it'll be on every single jury instruction that you hear that the judge is going to read to them. Are they allowed to consider it? No. Are they aware that they'll be making a statement? You know, I think you would know as well as anybody else, potentially. So could it come as early as Monday? Potentially. It could. It really depends on the jurors themselves. Remember, they're given absolutely zero time restrictions. So they can reach a verdict in a matter of hours legally, or they could reach a verdict months and months from now. It's completely up to them.
Sure. If it was a completely streamlined process, what they have to do is they have to go through each of these 3-page forms, 165 of them, and check the box, is that right? Or sign the line with what they believe is the accurate decision, guilty or not guilty by reason of insanity?
That's right. Either guilty, not guilty, which would be unlikely given the defense, or not guilty by reason of insanity. And there will be those 3 lines with a blank next to them. They will be instructed to put an X next to the line that they believe best fits, and then the jury foreperson will be asked to sign the bottom. So it's a relatively similar verdict form for every single count. Sometimes you heard other words like interrogatories. That's just some additional decisions that the jurors need to make that they'll need to simply mark an X or fill in a box.
And you mentioned the foreman or the foreperson. Is that something the jury gets to select, or is that selected by the judge for them?
Really good question. That is completely up to the jurors themselves. That is going to be one of the first things that they are going to do. So when we hear the judge read the actual jury instructions tomorrow, he's going to say, ladies and gentlemen of the jury, one of the first things you need to do is go into the juror room and decide on your foreperson.
Got it. And they can elect based on whatever criteria they like.
Whatever criteria they like, and it's completely secret. So we will only know how they chose the foreperson if somebody chooses to speak down the road. And remember, we're not ever going to know who the foreperson is until the jury verdict form actually comes in and we see that individual's signature on the bottom, and at that point we'll know.
Gotcha. Well, with that, David, I think we're ready to wrap the day up. It does appear that court has ended our signal for the day, and that seems to make sense. We were wrapping things up and having private bench conferences there at the end, and so tomorrow is the big day, the closing arguments, starting at 9 a.m., and we know we have quite a few instructions to read, and you were telling me that it could take quite a while just to get through those.
It's gonna take quite a while in the morning. There's a lot of instructions, and then oftentimes the judge will read the verdict forms to the jurors right away. So that's a lot of reading, and so plan on arguments of counsel starting quite a while after court begins.
Okay. So with that, we'll say goodnight for now. I will let you know, everyone, that this evening we'll be establishing the link that we'll be using for the live stream tomorrow. We'll be embedding it onto our site and apps so that any of you can find it, bookmark it, get ready to watch. And certainly we'll have all of our standard start in the morning. We'll have a replay, a recap that'll get you all geared up for the day, for what to expect. And then, of course, we'll cover in their entirety the closing arguments, and then the jury being finally designated, the actual voting jurors, and then dismissed to their deliberations. We'll cover it from the beginning to the end tomorrow. So thank you, David, for joining us. Thank you all for watching us today throughout this day where we did a lot of squabbling over simple things like words, but things that, as we've learned now, can be very important in the future. So thank you all. Have a great night, and we'll see you bright and early tomorrow morning.